Hi, Chair, you hear me okay?
Hey, good morning, Keith. Yes, I'm hearing you there. Are you hearing me?
Yes, that's grand. So that's us live now, Chair.
Okay. Okay, thank you. Thank you, and I now declare the meeting of the Health Committee open to the public online. I'd like to welcome all of the members who are participating by video conferencing and also to remind members about the protocols regarding the use of electronic devices. So, moving on then to apologies, members. Clerk, are you aware of any apologies?
Yes, Chair, just to say that Deborah has to leave early to attend a funeral and she's given her proxy vote to Pam when she leaves.
Okay, thank you. Members aware of any apologies? No. Okay, thank you. Members are still in the audience there. Clerk, are they going to be brought up into the spotlight or
Yes,
not
we're
quite yet?
we're getting them brought up now, Chair, just.
Okay, thank you. Okay, so yeah, I can start to see members now. That's better. Thank you. Okay, members, just a couple of brief items of Chairperson's business. The first thing that I want to note is a very sad landmark in relation to the COVID-19 pandemic, whereby in the past, over the Christmas period, we crossed over into over 3,000 people who have now lost their lives as a result of COVID-19. That's a tragedy for each and every one of those individuals, for their families, for their communities, and I think it's been a really, really difficult time, and I think that's a very sobering figure, and one that we all reflect, and I know we do reflect on, and I know that all the work we do is bearing that in mind. The other thing that I want to say is the ongoing danger out there of the Omicron variant and the fact of how transmissible it is, and just to reinforce the messaging to the public to take care, to abide by the public health guidelines, to do all the very basic things such as social distancing, washing hands, wearing face coverings, all of those things which we know help to suppress and drive down transmission of this horrible virus. I also just want to advise members that I attended a policy forum event this week at the start of this week on Monday morning. It included the Minister, it included Professor Bengoa. It was around the theme of transformation and what needs to happen in terms of the service. A very, very interesting and a very useful session, I have to say, and clear that there's great awareness of the extent of the difficulties and also a great awareness of the potential solutions, and that it requires will to try to move and create that new health service that we all know that is so badly needed. And finally, I just want to comment upon and just to acknowledge the informal meetings that the committee have done over the past couple of weeks on the adoption bill with adoptive parents, foster carers and young people in care. And just to acknowledge and thank each and every one of those people who participated in those and contributed to the committee's work in that regard. And I'm looking forward to the next meeting with the foster carers. So thank you for that, members. Moving on then to draft minutes. I refer you to the draft minutes, firstly, of the meeting of the 16th of December, which is at tab 3.1 of your pack there. Are members content with those minutes? Yeah, thank you, members. I also refer members to the minutes of the meeting of the 6th of January, which are at tab 3.2 of the pack. Are members content with those minutes? Yeah, thank you. And finally, in terms of minutes, members, the third set of minutes are the minutes of the 11th of January, which are tab 3.3 of the table pack. Are members content with those minutes? Yeah, content. Thank you, members. And there are no matters arising, members, from those. So we're moving now then, members, into our first piece of work this morning, which is around the Autism Amendment Bill, and this is our consideration of the final report. I'd like to remind you that the draft report on the bill was discussed at our meeting on Tuesday, and members asked for a few changes to be made. The revised draft is at tab 5.4 of the table pack. Copies of the bill and the explanatory financial memorandum are at tabs 5.1 and 5.2 of your pack. And I would also draw members' attention to the letter from the Minister in relation to the bill at tab 5.3. So I would remind members that the report must be agreed today in order to be able to reach the end of committee stage by the 14th of January. So I would like to now ask the clerk to speak to that report, please, and take us through it. Thank you, clerk.
Thanks, Chair. Just to highlight, I only really want to cover the areas where we'd agreed that maybe look at the wording of it again. So I would point you first of all to page 18 of the table pack, which is the executive summary. So the executive summary of the report is basically just pulling out the recommendations and the agreed amendments. So you can have a look at it there, but it's all near enough a lift from the lower part of the report in consideration. So I'll take you first of all to the first change that was discussed, and that was in relation to clause 2 and around the mandatory training issue. So if you go to page 29 of the pack, and that's paragraphs 25, 26 and 27, you'll see there highlighted in yellow the changes that have been made. So the first change was the change the last line of paragraph 25 to say, but felt that it placing a duty for mandatory training for all staff was outside the scope of the bill. Paragraph 26 then references the Assembly motion from February 2020 around mandatory training for trainee teachers, teachers and classroom assistants. And then paragraph 27, again, I've just referenced the previous motion where I've said consider mandatory autism training for relevant frontline staff, including trainee teachers, teachers and classroom assistants. So those are the sort of changes that had been suggested. So it's just to check if members are content with those changes.
Yeah. Thank you.
Yeah, members appear content. I just want to go to Pam Cameron. Pam, were you looking to come in there?
Yeah, Chair, just wanted to come in at the beginning to declare an interest as the bill sponsor, and also just to thank committee for their work on the bill to date.
Okay, thank you, Pam. Thank you, and thank you, Clerk. So members are content with that as amended, Clerk, and then if you could bring us to the second area.
The second area is page 34, and it's paragraph 45. So there was some discussion around, you Chair had highlighted the need for the reviewer to be independent of any organisation or organisations. So, and Colin had also suggested something around recognising that the reviewer needs to be reflective of the whole sector. So if you see the last line there in paragraph 45 states, the committee envisages that the role of the reviewer reviewer, sorry, I shouldn't say as, being reflective of the whole sector and should be independent of any organisation / organisations.
Yeah, I think that does. So are members broadly content with that amendment? Yeah, to that amendment to the report. Okay, so that's all the issues that we changed from the substantive one that we discussed. Clerk, am I correct about that?
Yes, yeah. That's the only changes.
Okay, so I'll return then, and those changes are included within the sections, and I'm going to go through section by section now, members. So this is our formal consideration now of each of the sections of the report. So Pam has declared her interest. Any other members wish to declare an interest before we go into the formal consideration? No, thank you. I refer members then to the title page, the table of contents, committee powers, and membership and list of abbreviations and acronyms, which are pages 13 to 17 of the pack. Are members content with this section as drafted? Yeah, content. Thank you, members. I next refer members to the executive summary, which is at pages 18 to 22 of the pack. Are members content with this section as drafted? Yeah, members are content as drafted. Thank you. I refer members to the introduction and committee approach at paragraphs 1 to 16, which are contained at pages 23 to 26 of the pack. Are members content with this section as drafted? Yep, content. Thank you, members. I refer you then, members, to the clauses of the bill at paragraphs 17 to 50, and those are contained at pages 27 to 35 of your pack. Are members content with this section as drafted?
Yeah.
Content, thank you. I refer members to the clause by clause consideration of the bill at paragraphs 51 to 66 on page 36 to 39 of the pack. Are members content with this section as drafted? Content, thank you, members. And I refer members to the appendices at pages 40 of the pack. Are members content with this section as drafted? Yep, thank you, members. And are members content? So that's the contents of the report then. Two other items to agree, members. Are members content that the minutes from this meeting are approved by the chair so that they can be included as part of this report? Yep, content, thank you, members. And finally, in relation to this one, are members content for committee staff to make any necessary formatting changes in advance of the electronic publication? Yep, content. And finally then, members, in relation to the publishing of the report, so I would like to put the question to you that the Committee for Health is content for the report on the Autism Amendment Bill to be published. Are members content? Yep, thank you. And the last item then in relation to the Autism Bill is in relation to agreement to issue a link of the report to the organisations who provided evidence to the committee and to the department. Are members content that we forward that link? Yeah, members content. Okay, I would like to also thank committee members for their consideration again of what was quite an extensive bill, a very important bill. I think we all agree. I also would like to thank everyone who gave us evidence, and I think there was very, very valuable evidence presented, which allowed us then to make a number of slight improvements to the bill. But I think it's a really important one, and I think the key thing that everyone wishes now in relation to this is that we see implementation, that we see real change developing. But as far as the committee's work is gone, and I want to acknowledge the work of Pam, the work of the all-party group, and I know Cathal Boylan and various other MLAs have been involved in that work over a very long period of time. And I just want to acknowledge that, as well as the key people within the sector who have worked hard, Autism NI, National Autism Society. And a lot of people out there are very conscious of the difficulties and are very active in trying to provide some of the solutions. So I want to thank all of you. I also want to thank the clerk and the committee staff for the work that they have done in relation to this bill as well. And it is substantial in relation to any bill, but this one has been fairly onerous in terms of workload as well. So thank you all for that. Okay, members. So I'm moving on then to item 6, which is the Hospital Parking Charges Bill and consideration of written submissions. I refer members to the clerk's memo, which is tab 6.1 of the pack, and to the bill and the EFM at tabs 6.2 to 6.3. Do members wish to declare an interest? Any members wish to declare an interest? No, thank you. Moving on then, the call for evidence on the bill closed on the 22nd of December, and a total of 6 submissions were received. These can be found at tab 6.4 to 6.9 of the pack. The committee should now decide which organisations it wishes to hear oral evidence from. Are members content to schedule those organisations that have provided already written submissions? Yeah, members are content. Are members content that the department is invited also to give oral evidence? Yeah, members are content. And I'll just check, clerk, it was also suggested that there are some areas, I think, Scotland and Wales, and I think England are currently bringing in something of this nature that we would have liked to have heard from somewhere where this is operating to see what the difficulties are and what the hurdles might be. Can you advise how we might include that?
Yes, Chair, just to say, I've had discussions in relation to our research team carrying out some work on this around what's happening in other jurisdictions, just to get a clearer picture on it. So I'm currently discussing that with the research team at the minute. Okay. Well, so and we can assess then pending that report then who else it might be useful to hear from in that respect. Are members content with that? Yep, thank you. Okay, members, any other comments or suggestions of people of who we should invite to give oral evidence in relation to this bill? No, I'm not seeing. Sure. Carol, go ahead.
Sorry, Chair. It just occurred to me, if we haven't done it already, but even Marie Curie and some of the cancer charities who are supporting individuals and families, because they were the people, first of all, who brought the bill to Fran McCann and then to Aisling Riley. So it might be an idea for them to give evidence as well.
Okay, so Marie Curie, and was there another one you mentioned there, Carol, or
no? It was just some of the charities who are helping families and individuals through cancer treatment. So if Marie Curie can cover that, fair enough.
Okay, I'll just check with the clerk. What would the logistics be of that, clerk?
Chair, we can certainly get in touch with them to see if they'd be willing to come and give evidence. It would just be scheduling a few additional sessions.
Okay, Colin.
Thank you, Chair. Yeah, I suppose it's just on that last bit that the clerk has said. I mean, we can see what's going to happen here. Trust and departments say this is bad, we need the money. Just about every other sector is going to say this is good. Maybe in the interest of trying to get this moving as quickly as possible, that we don't delay it by having to put in extra sessions. Is there a way of just minimising, not to minimise the voice, but it's such a clear-cut issue, that there are just basically two sides. Those that get the money want to keep it. Those that have to pay the money don't want to. And if we end up with too many presenters, we're just going to be hearing the same information over and over again, and I just don't want to impede this bill by preventing it from getting moving as quickly as possible. And if the clerk has said there that we're into that stage of we'll have to schedule extra sessions, is there a way of doing it that maybe we could bring all together that are one side, all together on the other side, and try and get it done in session so that we can progress the bill as quickly as possible? Because whilst something like maybe the autism and adoption, there's so many different views and varying views. I think you can see from the written submissions that this has fallen down into the two camps pretty much.
Okay, yeah. I have an indication from Alan, and then I'll come back to you, Carol. So Alan first.
Yeah, thanks, Chair. Chair, I don't entirely agree with Colin that it's a money yes or no issue. I think that there's implications, maybe unintended consequences of this action, and I think that we have to take a very holistic view of it rather than just settling for the argument: is it better to raise the money or better not to? As I say, there are a lot of other issues that we've already discussed, and hopefully, as we go through the consideration of the bill, we will look at all the potential unintended consequences. But one of the bodies I thought that maybe should be invited, and excuse me, I don't know the full name of it, but there is a statutory body, I think, that looks after the interests of patients. Maybe somebody can help me with the name of that committee. But
Patient Client Council.
I think that's it. It might be useful maybe to ask them to make a contribution from a patient's perspective. They may have something to offer us. So suggest maybe that we ask them, invite them. Thank you, Mr. Chairman.
Okay, well, listen, there's two further suggestions there. Pam, go ahead, and then I'll come to Paula, and I'll come back to you, Carol. I will come back to you. So, Pam.
Yeah, thank you, Chair. I don't disagree with Alan there, actually, and I think we do need to be cautious. I understand where Colin's coming from, but I think we do need to be careful that we're talking about legislation here, and I think rushed legislation can be very dangerous, and there could well be unintended consequences, and we need to fully explore the outworkings of this bill and the impact that it may have on services, on trust services, and really make sure that we do go into the detail that we should be in terms of scrutiny of the bill. So I think it's almost the opposite from what Colin's saying. While I understand where he's coming from, I think we need to be very careful and very cautious that we're not actually damaging the health service in some way further. Whilst in an ideal world, I think we'd all love to give everything for free. But I think we just need to be sensible and ensure that the proper scrutiny does take place at committee.
Paula?
Thank you, Chair. I agree with Pam and Alan as regards, making sure that we get this right, the unintended consequences, etc. I suppose the other aspect that I raised at second stage was the issue around public transport. And I know it's probably sits slightly outside the bill, but I do think that there's a need for us to engage with, potential alternatives or ways in which we can be better partnering up public transport and the need for sort of more green travel with what this was actually intending, and that's about supporting car owners and drivers. So I'm just wondering, is that something that we need to look at as well?
Okay, and Carol, I had said I would come back to yourself there.
Yeah, so Alan just prompted the Patient Client Council, also Macmillan, and even the Rural Community Network, because a lot of families are having to travel. Again, like other members, regardless where this may fall or not, it is legislation, and we need to have as much. I do get your point, Colin, and you can also add. You could add lots of groups into that, including public transport, but it is outside the scope of the bill, and maybe it's something we could put in the report. But I would certainly like to add, even if it's an opportunity to give those groups the possibility of providing additional written evidence, and if they feel that they need to come to the committee, then we should do that, as we do with any other piece of legislation going through committees.
Okay, so what I'll do is then, what I think is best is to ask Keith, who will have taken a note of that, and ask him to see how that would work out logistics wise. We have had it out, I suppose, on public consultation, but I also agree that we do need to apply due rigour, and that it is important in that sense. So I certainly don't want to foreshorten anything in a way that would impact the quality. So I'll ask Keith to come back with maybe to the committee on that, and we'll make a further decision. Pam?
Thanks, Chair. It's just occurring to me that, and I agree with the concerns of Paula's around transport and all those issues. I understand that the scope of the bill may not allow for all of that, but I think they are still conversations we need to be having with individuals. And I'm just wondering too, what role local government has in all of this, and are we looking at even consulting with, say, local traders and looking at the knock-on impact that the capacity in terms of car parking, what impact that may have on other walks of life, such as retail, trade, local government. I think we should actually be putting this net out as wide as possible to ensure that we're looking at every avenue and making sure all the areas are covered of concern.
Yeah, well, so I suppose that's my reason for mentioning the public consultations. The net went out completely widely. If we start to, my concern would be, but I will bring the clerk back in, my concern would be if we start to approach people, then do we end up in danger of skewing it any particular way? The other point I suppose to make is that, and this is why I think it's important that we hear from other areas that have done it, clearly a lot of these issues have been considered by them, and maybe that's a way to get to some of those other issues with areas that have real life, real-time experience of introducing this measure, and clearly in that sense it can be done. So I thought that was one of the ways. I'll take a view, Clerk. What's your thoughts there in relation to the discussion and how we might be able to move that forward in the way that committee members are suggesting?
Well, Chair, if members were content, we can write out and get in touch with all these organisations that have been mentioned to see if they, first of all, want to submit some written evidence to us. Because, like you said, we did go out for public consultation and anybody could have responded. Now, maybe timeframes and stuff prevented some people from responding. So I think as a first step, it might be worth writing to them and asking if they would like to either submit written evidence or if they would like to come before the committee as a first step. And we can try and get a tight turnaround on that as well, because we were planning to try and take evidence on this sort of the first week in February. So there is a wee bit of time to try and line up, similar groups, and no doubt we'll have the trusts together for one session. We'll try and bring other groups together for one session. We'll manage it as best we can. But I suppose, first of all, we need to know who exactly wants to come and give evidence to us. Because some of these organisations may just not have capacity to come, or maybe lining up with some other organisations that have already submitted evidence. So I would suggest that, Chair, as a first step, that we'll get in touch, write to them and ask for if they'd be prepared to send in written evidence, and if they wanted to come and give evidence orally as well.
Chair.
Carol, please.
Yeah, it is very briefly. There was over 1,000 responses to the bill when Aisling and Catherine came in front of the committee. That's one of the things that I thought was really clear, that there is a huge public interest in this, particularly for people who have been impacted. So it's just to bear that in mind as well. We don't need to go out and do another consultation on the bill. It's already been done.
Yeah. So that will provide those organisations maybe with a second opportunity. I think it would also be useful, Clerk, if we could identify someone within the Scottish or Welsh systems who have been through this and who may have an overarching experience of the challenges or the difficulties, or that would have to be then contextualised in our own situation. But it may be useful to have that. So are members then content that the clerk will do a further piece of work on that? And also we have agreed that the people that we have already agreed, but this is additional to those. Pam and then Paula, briefly again, please.
Thanks, Chair. No, I'm just wondering whether, have we checked with the department to see if there have been any works commissioned into looking at what the buyers for the health workforce are? Is there any commissioned work in and around actually diving into that detail and finding out what those buyers are? Could we ask the department if they've done that, or if they're considering looking into that particular topic to find out whether car parking has been maybe a buyer to actually people coming to work in the health service? And if they have done that, it'd be good to see those findings.
Okay, and Paula?
Sorry, Chair, that was my hand from earlier.
Okay. So, Clerk, can you draw that all together, and we'll come back and we'll bring that back to members to see how we progress that in a way that members are keen to do. Okay. Okay. Thank you, members. And I'm going to move on then to our item 7, which is the Adoption and Children Bill, and this is the departmental response to the evidence that we have already heard on the Adoption and Children Bill. I refer members to the papers at tab 7 of the pack, which include a copy of the bill and EFM at tab 7.1 and 7.2. And there are several items of correspondence from the department in relation to the bill. These include the department's response to stakeholder evidence at tab 7.3, the outcome of considerations based on written evidence provided to the committee at tab 7.4, and a list of proposed additional amendments which the department intends to table at consideration stage at tab 7.5. I would also like to draw the members' attention to the correspondence from Action for Children and the NSPCC at tab 7.8 and tab 7.9. And then further included in the information in the table pack at tab 7.13 is a submission from some birth mothers and adoptees in relation to the mother and babies' homes. So I would now like to welcome by Starleaf, Eilish McDaniel. Are you able to hear us there, Eilish?
I can indeed, Chair. Good morning.
Good morning. And Eilish is joined by Julie Stevenson, who is head of the Adoption and Children Bill team. Can you hear us okay, Julie?
I can. Good morning.
Thank you, Julie, and we're hearing you loud and clear here. And Frances Nicholson, who is a Social Services Officer. Can you hear us okay, Frances?
I can indeed. Thank you.
Okay. Thank you. So you're all very welcome to committee. I know you've all been here. I think all of you have been with us before, but we welcome your attendance this morning, and we're looking forward to your presentation and some questions and answers from members in relation to this very important, I think we all agree, very important and long-awaited bill as well. So I think there's a huge interest in relation to that. So Eilish, I'll go back to yourself just to see, is it you that's doing the opening remarks?
It is, Chair. Yes. Thank you. So I'd like to thank the committee for the opportunity again to provide you with further briefing on the Adoption and Children Bill. The Chair has reflected that the committee wrote to the Department on the 18th of October seeking its views on the issues raised by stakeholders in their written submissions in response to the committee's call for evidence on the bill. The Minister provided a written response to these on the 29th of November and indicated that in relation to 6 areas of concern raised in respect to 5 clauses, the Department would review the policy position with a view to deciding whether any amendments should be brought forward during the consideration stage of the bill. Following completion of that review, the Minister wrote again to the committee on the 21st of December to advise members of his decisions in relation to each matter. In that letter, the Minister confirmed that he intends to bring forward amendments to 3 of the clauses, which were subject to review, in order to address issues raised by stakeholders. The Minister also set out his reasons for deciding not to make further amendments relating to the other matters and the clauses reviewed. In addition, the Minister also outlined a number of other amendments which he intends to bring forward. With the committee's agreement, then I'll provide a brief overview of the amendments which the Minister intends to table and the reasons why. In relation to the 3 areas of concern, the Minister considers that no further amendment is necessary. Firstly, I will speak to the clauses that we propose to amend following consideration of the issues raised. So starting with clause 119, stakeholders were of the view that special guardianship support should be provided for on the same basis as adoption support. The Department reviewed the provision in clause 119, which is new Article 14F of the Children Order, and compared it with the provision in clause 5, which provides for adoption support. One key difference identified was that, unlike adoption support, there is currently no duty and trust on the face of the bill to conduct an assessment of needs for special guardian support services in respect of certain categories of people on request. The Department's intention had been to exercise the power provided in paragraph 3 of new Article 14F and following consultation to prescribe such categories of people in regulations. However, given the calls from stakeholders for parity of approach with adoption support, the Department will now table an amendment to clause 119, new Article 14F3, to place a duty on trust to provide such an assessment if requested by or on behalf of children with respect to whom an SGO has been applied for or is in place, and the duty to provide an assessment will also apply to current or prospective special guardians and to the child's parents. By placing such provision in the bill, this will more clearly demonstrate the Department's commitment to ensuring that assessments are undertaken where they're requested, and will ensure that the approach for undertaking such assessments is broadly consistent with provision in clause 5 in relation to assessments of need for adoption support services. We will also retain the provision in new Article 14F3, which enables the Department to prescribe additional categories of persons for whom an assessment must be undertaken on request, and to determine who those additional categories of persons should be. We will capture and monitor the nature and range of special guardianship support needs in implementation. Turning to clause 132, stakeholders suggested that clause 132 of the bill should be amended to more clearly reflect that advocacy services will be independent of trusts. In order to address that, the Department will table an amendment which will insert the word independent in the heading of that clause, and also the heading of new Article 45A, which is to be inserted into the Children Order. We do not propose to amend the wording of the clause. While the advocacy clause itself does not specify independent services, the clause does contain regulation-making powers that allow the Department to specify who may not provide advocacy services. It is intended that this will be used to ensure independence by specifying that services may not be provided by persons linked to the service that is the subject of representations for which advocacy is being provided. And in addition, the bill provides a further regulation-making power requiring trusts to monitor the steps that they've taken with a view to ensuring that they comply with regulations made for the purpose of ensuring independence. I want to assure committee that this doesn't mean that a trust can't provide advocacy services. However, in guidance, we will make it clear that where it does, no person associated with the case under consideration, directly or in line management terms for which advocacy is being sought, can have any part to play in providing advocacy services. Turning to clause 133, which relates to the definition of harm. Clause 133 amends the definition of harm in the Children Order to include a child seeing or hearing the ill treatment of another person. As a result, courts, police and the trusts will be required to consider the effect on a child of witnessing domestic abuse when making critical decisions about their protection, care or upbringing. In response to representations made by a number of stakeholders and also by members during the second stage debate on the bill, the Minister gave a commitment to consider extending the provision to include where a child is adversely impacted by such abuse, even if they haven't seen or heard it taking place. Following consultation with Council, the Minister has decided to amend clause 133, and as a result, the definition of harm in the Children Order would be amended to read: harm means ill treatment or the impairment of health or development, including, for example, impairment suffered from seeing, hearing, or being present during the ill treatment of another, and the question of whether harm is significant shall be determined in accordance with Article 53. This brings the definition of harm within the Children Order more in line with the Domestic Abuse and Civil Proceedings Act, Northern Ireland 2021. And while it doesn't follow the format of the provision within the 2021 Act in full, it delivers the desired effect without compromising the definition of harm in the Children Order, the primary focus of which is on physical, sexual or emotional harm caused directly to a child. I'll move on now to the clauses that following review the Minister has decided not to amend. Clauses 5 and 119. Stakeholders expressed concern that Clause 5 does not place a duty on the Trust to provide adoption support services which may be identified as needed following an assessment. Likewise, as mentioned earlier, stakeholders were of the view that special guardianship support should be provided for on the same basis as adoption support. We've reconsidered the policy underpinning both clauses, that's clauses 5 and 119, and decided that this remains the best way to proceed in policy terms. Both clauses already provided power for the Department by way of regulations to specify certain categories of people to whom the Trust must provide the support which has been assessed as needed. This could include, for example, the adoptive parent or adoptive child, or for special guardianship support, the child in respect of whom an SGO is in force, and special guardian. The Department's reason for providing the power to specify the requirements in regulations was to give trusts some initial flexibility to decide in all cases whether to provide services assessed as needed. We want to ensure that social workers can target valuable resources where they are needed most. Trusts are best placed to decide on the basis of assessed need how best to provide support. The committee will be aware that this is the basis on which most health and social care services are currently provided. And in relation to SGOs, this will be a new permanence pathway for Northern Ireland, and it's difficult to predict the extent to which such orders will be sought and the support needs of those who seek them. As part of implementation, the Department will capture and monitor the nature and range of support needs for both adoption and special guardianship to determine whether at a future point to use the new powers to prescribe categories of persons for whom a trust must provide services assessed as needed. It's also worth noting that the bill also includes transitional provision, at paragraph 1 of Schedule 4, to amend the existing Adoption Order of 1987 to enable important elements of the new Adoption Support Services framework to be implemented in advance of full implementation of the bill. Using these powers, the intention is to implement the first phase of the Adoption Support Services framework as soon as possible. It is anticipated that the regulations, which would be made under the 1987 order, will give adoptive families, and that includes children placed for adoption, adopted children, prospective adopters, adoptive parents and their children an entitlement to receive an assessment of their adoption support needs and give related persons, that might be a natural parent, a relative, or any person the child has a relationship with that is beneficial to the child, to an entitlement to receive an assessment in relation to support for contact arrangements. It's also intended that the regulations will require trusts to make arrangements for the provision of a range of adoption support services, including financial support, therapeutic support services, assistance to ensure the continuance of adoptive relationships, including respite care, and assistance in relation to contact arrangements. The early implementation of elements of adoption support services and also the monitoring arrangements which we will put in place will then inform any decisions as to whether the Department should exercise its powers by way of regulations to be made under Clause 5 or Clause 119 of the Bill to place a duty on trusts to provide adoption or special guardianship support services which have been assessed as needed and specific categories of person. Moving on then to Clause 128, the Department agreed to consider whether it would be appropriate to amend Clause 128, new Article 34DA4, to provide that the payment received by a former foster carer under the GEM scheme should be in line with fostering allowances. The Minister has decided not to make such an amendment on the basis that it would be difficult to define in legislative terms, given the number of possible funding and permutations. Rates and payments available as part of the GEM scheme are currently set out in guidance developed by the Health and Social Care Board and are dependent on the circumstances of each individual case. The calculation of former foster carers' allowance under the scheme is not straightforward. There are a number of scenarios where allowance rates may be impacted because of individual circumstances. The GEM scheme guidance will be updated by the Department as part of implementation of the bill, and the rates and payments available will continue to be set out in that guidance. In his letter dated the 21st of December, the Minister also advised the Committee of his intention to table a number of further amendments to the bill. Starting with the removal of references to the Health and Social Care Board. The Health and Social Care Bill, which makes a provision for the Regional Health and Social Care Board to be dissolved, has now completed its final stage in the Assembly, as members are aware, and is currently awaiting royal assent. The Adoption and Children Bill now needs to be amended to remove references to the Regional Board. Clause 3 will be amended to remove the Regional Board from the definition of an adoption authority. Each Health and Social Care Trust will continue to be the adoption authority in relation to its area. Clauses 144 to 150 relating to the Northern Ireland Adoption and Children Act Register will also be amended to substitute references to the Regional Board with references to the Department. Finally, the definition of Regional Board will be removed from the interpretation section and provided at Clause 158 on the basis that such a definition will no longer be required on dissolution of the HSCB. Clause 42 of the Bill provides a power for the Department to prescribe in regulations the matters to be taken into account by an adoption agency in determining or making any report in respect of the suitability of any persons to adopt a child. In accordance with Clause 155, the negative resolution procedure would apply when making these regulations. During the second stage debate on the bill, Jim Allister MLA suggested that such regulations should be subject to affirmative resolution rather than negative resolution procedure. Mr. Allister stated he considered suitability of adopters was too important an issue not to be debated by the Assembly. Having given further consideration to the matter, the Minister has agreed that Clause 155.2 should be amended to include regulations made under Clause 42 in the list of regulations which will be subject to affirmative resolution procedure. This will be consistent with the approach being taken with other regulations to be made under Clause 98 of the Bill relating to individuals who may not prepare reports about suitability of a child for adoption or of a person's suitability to adopt a child. In order to give effect to Part 1 of Recommendation 4 from the report of the Truth Recovery Design Panel, which was published on the 5th of October 2021. Council has been instructed to draft a clause for inclusion in the bill, which will compel holders of records relevant to mother and baby institutions, Magdalen laundries and related institutions, to preserve and not destroy those records. The clause will include offences with associated penalties and for non-compliance. Turning then to clause 102. Access to information was one of the key themes which emerged from the work of the Truth, Recovery and Design panel and was identified as an issue for victims and survivors very early on in that process. Officials have met on a number of occasions the group of victims and survivors of mother and baby institutions to discuss in particular the provisions in the bill relating to disclosure of information. They're seeking a number of amendments to be made, and I understand that they've also written to the committee setting these out, and you reflected that in your opening remarks, Chair. There are 3 amendments that the Minister has agreed to consider making, and we're currently engaging with Council on the wording of these. 2 of the amendments relate to clause 102, which makes provision for pre-commencement adoptions. The intention is to extend the regulation-making powers to enable the Department to include in any regulations to be made under clause 102 new provisions relating to the disclosure of information for pre-commencement adoptions. This would enable all provision to be included in one set of regulations, rather than continuing to rely on the Adoption Agency's regulations of 1989, which are now more than 30 years old. It would also enable the Department, in consultation particularly with victims and survivors of mother and baby institutions, to agree more acceptable wording, as some have expressed concerns about the wording used in the 1989 regulations. Council has advised that while the general regulation-making powers in clause 9 of the bill would be sufficient to allow the Department to do this, he suggested that for clarity, it would be preferable to amend clause 102 to include a specific regulation-making power. The Department also intends to amend clause 102 to extend intermediary services to allow assistance to be provided to the natural parents of an adopted person who wishes to obtain information from an adoption agency and about the adoption. As currently drafted, intermediary services for such individuals are restricted to facilitating contact. The third proposed amendment then is to Schedule 2 of the bill. The Registrar General is required to advise any adopted person seeking access to their birth record that a counselling service is available to them. However, under paragraph 4 of Schedule 2 of the bill, people adopted before the 18th of December 1987 are required, rather than being given the option, to attend a counselling interview before the Registrar General can provide the information. Some victims and survivors of mother and baby institutions consider that this should not be the case, that they should be treated in the same way as other adopted adults and have the right to decide for themselves whether they avail of such counselling services. Taking account of this, the Department has engaged with the Registrar General's Office on this matter, and it's clear that process changes will be necessary to support this amendment, and there are concerns about those individuals seeking a copy of an original birth certificate who may not be aware that they were adopted. And while this is the case, the Department has decided that on balance, it should bring forward an amendment to the bill to remove paragraph 4 from Schedule 2. The duty on the Registrar General under paragraph 2 of that schedule to inform adopted adults of the availability of counselling services will continue to apply. It will be for the adopted adult, regardless of when they were adopted, to decide whether to avail of counselling services and from whom. And when the counselling service is sought or requested, there will continue to be a requirement to provide. We will ensure that victims and survivors of mother and baby institutions and others with a specific interest in access to adoption information are fully engaged in the process to develop any regulations to be made as part of implementation of the bill, which provide for the disclosure of information for pre-commencement adoptions and also intermediary services. We will also continue to work with them to agree practice guidance for adoption agencies on the sharing of information from adoption agency records to ensure that there is a consistent approach to the disclosure of adoption information across all adoption agencies. We've engaged an independent lawyer who's a data protection expert to assist with that work. Finally, the Minister advised the committee of his intention to table a number of amendments which are technical or consequential in nature. Clauses 25 and 26 set out rules about applications for other orders during the period that a child is placed for adoption or the adoption agency is authorised to place the child for adoption under Article 16, and also where a placement order has been made. Both clauses include references to applications for SGOs, stating that if an application has been made for an adoption order, any person wishing to apply for an SGO during this time must seek the leave of the court to make such an application. If a child has been placed for adoption and an adoption order has been applied for, the child will have been living with the prospective adoptive parents for a period of time. Officials have therefore considered that it would not be possible for another individual to meet the 1-year residence requirement for making an application for an SGO, and on that basis, Council was instructed to amend both clauses. However, Council has now identified a very narrow set of circumstances under which an individual could meet the requirements, and as a result, it's considered that the existing provisions in clauses 25 and 26 should be retained, and no amendment to these clauses will be tabled. The Department has determined, based on legal advice from the Departmental Solicitor and Legislative and Council, that outdated legislation given effect to an international adoption convention that is no longer in operation, that's the Adoption Hague Convention Act Northern Ireland 1969, should be repealed. The amendment will insert provision in Schedules 4 and 5 of the bill to repeal the 1969 Act and to insert savings provisions to ensure that the future rights of anyone adopted through a convention adoption order under the 1969 Act will not be negatively impacted by its repeal. The Department has agreed with the Department of Justice that a consequential amendment should be made to paragraph 6 of Schedule 2 to the Access to Justice Northern Ireland Order 2003, and this amendment will provide that legal aid services will not be funded for the provision of advice, assistance or representation to any children's court guardian for the purpose of proceedings under Clause 106 of the bill. Such an amendment will ensure that there's consistency of approach in relation to children's court guardians, whether they're appointed under the Children Order or under the bill. Chair, that concludes my summary of the amendments which the Minister intends to table for consideration stage of the bill. Work is ongoing with Council to draft the amendments, and these will be shared with the committee as soon as possible to enable the committee's report to be completed. Finally, I would like to emphasise to members that while the bill provides the overarching framework, the detailed operational arrangements required to give effect to the provisions in the bill will be set out in subordinate legislation. Approximately 20 sets of regulations will set out the arrangements governing the operation and practice of adoption agencies, health and social care trusts, and the GRO. These will make detailed provision in relation to key elements of the bill, such as adoption support, special guardianship orders, care planning, the disclosure of information to adopted people and others, inter-country adoptions, and the operation of the independent review mechanism. The bill also provides for the making of court directions and rules of court. Subordinate legislation and associated guidance will be brought forward in distinct phases, post-implementation, timed in accordance with the commencement of the relevant provisions in the bill. The intention is that we will work closely with key stakeholders throughout the drafting process. Full public consultation will also be undertaken on all subordinate legislation to be brought forward. All statutory rules will also be subject to committee scrutiny. Committee members will therefore have the opportunity to provide input to the subordinate legislation, thereby shaping how the bill will operate in practice following royal assent. Also, those statutory rules made under the affirmative procedure will be subject to debate by the Assembly. I'd like to thank members for your patience, and we're now happy to answer any questions that you may have.
Okay, thank you, Alice. Yes, it is, and I do acknowledge there is a huge amount within this bill, and that's one of the issues with it, I suppose. So I will try to be as succinct as possible with a few questions, and then go to members, and I just ask everyone to be as succinct as possible, because there probably is a lot of areas to get through. Just a quick one in terms of where you finished off there. You'd said about the amendments. When can we expect to see those amendments, the draft text or the text of those amendments?
Okay, so they are a number of them have already been drafted. Some are in the process of being drafted. As soon as all of them are complete, we will get them to you as soon as possible. I'll ask Julie maybe if she can be more specific than that.
Yes, I understand it from liaison with the committee clerk that you would need these probably by the week after next to inform your clause by clause consideration on, is it the 24th? So we would aim to hopefully have them to you by the end of next week. So by probably Friday the 21st or 20th, if that's okay.
Okay, yeah, I suppose the sooner the better, I suppose, just in that regard, Julie, so appreciate that. The other one that I wanted to ask you just kind of briefly, Eilish, in clause 69 there it refers to, it provides that where a child is born illegitimate and adopted by one of its natural parents. I'm a bit shocked in this day and age to still see that type of language. I take the view that there's no such thing as an illegitimate child, to be quite honest. Why is that terminology been used? And it has been raised actually as well in evidence, but it has been raised as to is that a sensitive terminology in the circumstances, or are there other alternatives that could be looked at?
Sure. This was raised in consultation, and following consultation, we raised the issue with council. It's not simply a matter of use of language. I think there are implications for across the statute book, so it's not just a matter of changing it within the Adoption and Children Bill, and I think to change it is probably beyond the scope of the bill. So I just want to assure you we considered it, we sought advice on it, and the advice is that the change is not possible solely within the Adoption and Children Bill because it has wider implications.
Okay, I want to move on then to the whole area of assessment and support provided following assessment. So can you tell me how much has been earmarked to provide services following any assessment?
Okay, so I'm going to rely on Julie and Francis potentially to come in behind me here with more detail. But in terms of the headline figure, we have bid for around £14.8 million over a period of 3 years to provide both adoption support and special guardianship support services. We can set out for you, Chair, if it's necessary to do just exactly how that has been broken down and the assumptions that we have used to arrive at that figure. But that's the headline figure over 3 years, starting in 23-24, when our intention would be to start rolling out enhancements to adoption support services. Julie and Francis, do you want to say anything further?
Yeah, we have, I think we have, our costings have been based very much on the assumption that support will be provided for the child themselves, and also any support needed for either the adoptive parent or in relation to special guardianship, the special guardian themselves. The element that is for adoption support is in addition to the existing funding that is provided for adoption allowances already currently. The special guardianship support as well has taken into account that because of our 1 year residence requirement, we do expect that there will be the number of special guardianship applications going forward. It will be a rising amount. In the first year, we don't expect large numbers of these applications because of the residence requirements. So that will increase, gradually over the period of the 3 years. And also we are planning that we would keep the types of support that would be available very consistent between adoption support services and special guardianship, to include therapeutic care, support for maintaining the placement, support in relation to contact arrangements, and also particularly in relation to adoption, provision for counselling for birth parents.
Okay, I just wanted to sort of get a bit of context, but what I'm really also keen to understand is why there cannot be a duty on the department to provide services based on the assessment. And I will I suppose declare my own experience, my own interest as a social worker previously, and I liken this to the issue of carers assessments, whereby there's a duty to provide a carers assessment, but no duty to provide for the needs that are identified within that. And I believe that has a kind of a chilling effect on the amount of assessments that are done, because people understand that the assessment will not necessarily lead to anything. I also put it in the context of that these are some of the absolutely most vulnerable children and most disadvantaged children in our system, and that there's a finite number of them, and a smallish number of them in the greater scheme of things. And I'm wondering why we can't append a duty to provide those services to those very vulnerable children and families around them.
I tried to set that out in the opening remarks. Chair, the thinking is to try and provide some initial flexibility to trust, and you've made reference to it yourself in relation to carers assessments, to create some level of parity with existing arrangements in terms of how we assess and what we do on the basis of those assessments. I have referred to the fact that we do have powers in the bill which we can exercise, and that would do what you are suggesting needs to be done. That is the creation of a duty to provide on the basis of an assessment. Now, what we've agreed to do is to keep everything under review, to monitor who is being supported with what, both in relation to adoption and special guardianship, and determine on the basis of that whether or not to exercise those powers to actually require the provision of services to specific categories of people who we would name within regulations. So some initial flexibility, parity with other service and provision, but with powers in place to require, if we consider that is necessary, on the basis of monitoring and review activity.
Okay, well, I'll move on then. I do want to ask you a question on behalf of one of the young people directly who we met with in relation to this issue last week. And the young person's question was, if special SGOs become law, will this mean that the SGO could remove a child from a care family against the child's wishes? So what's your thoughts on that, Eilish?
Well, I think the views of the child or young person are going to be central to everything that is done under the bill, and that's why, for example, too, we've introduced advocacy services on a statutory basis. So I would find it very difficult that if a child was so adamant that they didn't want to be removed from a care arrangement to be placed in a special guardianship arrangement, that actually that would be imposed upon the child. I would be incredibly surprised, Chair. But I just want to assure you that seeking the views of the child, listening to what children and young people have to say, providing them with advocacy support in the process. It will be central to everything that is done, and is currently the case under the Children Order also.
Could I just add there as well, the special guardianship regulations will set out all of the matters that have to be considered and presented to the court in the court report to enable the court to decide whether to make the special guardianship order. And one of the issues in that is about reflecting the wishes and feelings of the child in relation to the making of such an order. So the trust will be required to take account of the child's feelings and present those to the court for consideration as part of the decision whether to make such an order.
And the other thing I suppose to add is the introduction of that additional safeguard in Northern Ireland that isn't present elsewhere. That's the introduction of a panel arrangement where a trust's report in relation to a special guardianship order will be subject to examination or review by a panel. And again, that it's just another check and balance and safeguard that we've introduced into the system of SGOs in Northern Ireland for the reasons that young person has stated.
Okay. So a final one from me then for now before I go to members there, and I'll go to Deborah Erskine first, given that Deborah may have to leave. I'll go to Deborah, then Carol Nicullen, then Pam, then Paula, then Orlea. So just to let people know that's the order I'm coming to you there. You've mentioned there, I think a couple of times, Eilish, that the department, that there will be over 20 sets of regulations that will be needed to implement, will need to be implemented to following the bill. How long do you think it'll take the department to bring those forward? Okay, so we've already done some phasing work, and again, I'm going to rely on Julie to come in behind me here and provide the detail. But in terms of a general comment, phasing will happen over 3 years, starting in 23-24. Taken us right the way up to I think 31st of March in 2026, and we're very clear by way of the phasing schedule what regulations will be made in each of those phases. Again, this is all set out, Chair, and if it would help the committee, it's certainly information that we're very happy to provide you with, but 3 phases over 3 financial years, and we're very clear about what regulations would be made in each of those phases. Julie, do you want to add anything?
Yeah, phase 1, for example, we would move as quickly as possible to implement anything that doesn't require regulations or guidance. So, for example, the definition of harm could probably be commenced very, very quickly. And also, as Eilish mentioned, we would do the early transitional regulations in order to introduce some elements of the adoption support provisions. Phase 2 then would be probably focusing on a number of different regulations for some of the Children Order amendments, such as your foster panel regulations, commencing the Children in Need guidance, Children in Need provisions around Article 18 payments and short breaks, for example, and then also working on the adoption framework as a whole. It's really interlinked and requires about 10 sets of regulations to be made just to give effect to the whole of the adoption framework under the bill. So it's quite a big piece of work, which is why it's in phase 2. And then the final phase would probably be special guardianship orders and care planning regulations. So although work would commence on those at the very start, because of the complexity and the need for full, the consultation and all, we would hope to have those ready by the beginning of phase 3. And towards the end of that phase would be the Adoption and Children Act register, on the basis that that database is already operational on a non-statutory basis, and also the design and implementation of an IRM, an independent review mechanism.
Okay, thank you. So I'm going to go then to members, and I'll bring first of all Deborah Erskine. Go ahead, Deborah, please.
Thank you, Chair, and I want to thank the panel for giving their evidence. This is an important bill, and it's been a long time coming, and we've heard very powerful evidence as a committee. I want to touch on perhaps something there that the Chair was indicating towards as well in terms of funding and things. The Minister has indicated that while the business case has been approved by the Department of Finance for the bill, this won't be revisited until it has gained royal assent. So how will the amendments outlined affect annual expenditure, and will a failure to explore these issues now lead to delay in implementation?
Okay, so you're quite right, Deborah. The business case has been developed and at a very high level and needs to be further developed. But I just want to assure you that we have already submitted bids for funding to support the implementation of the bill under the 3-year spending review exercise. So a bid has been already submitted for 23-24 to support the implementation of adoption support services, for example, in that year. I don't know whether that sufficiently answers your question, Deborah.
Could I also add that in relation to the amendments, we actually have considered whether there would be additional costs arising from those. The only one that potentially would have had a cost implication would have been the duty to undertake assessments for special guardianship support. And we had already costed, because our intention had been to set those requirements out in regulations anyway, using the powers under the bill. We had already costed on the basis that such assessments would be carried out. So the amendment actually is not going to incur any additional financial cost in that regard. The other amendments, for example, the amendment to the definition of harm or the advocacy, won't actually incur any additional expenditure that would require the business case to be revisited at this stage at the moment.
Okay, so then as a result, you're not envisaging that there will be any delay in implementation then, from a financial point of view or otherwise?
Well, it's all subject, Deborah, to bids being successful, etc. And obviously, it needs to be considered in the round in terms of the wider health and social care budgetary requirements. So bids have been made, all subject to further consideration and approval.
Okay, thank you.
Okay. Anything else, Deborah?
No, that's me, Chair. Thank you.
Okay, going then to Carol. Go ahead, Carol, please.
Happy New Year, Julie, Eilish and Francis. Eilish, if I could ask, even if you could just adjust your screen, because those who are with brilliant hearing impairment, I can only see from your nose up, so...
Apologies, I couldn't see myself, actually.
Yeah, well, I know. But listen, thanks for your input. I would just like to ask, in the process of bringing the amendments forward, could you consider, if you haven't already done so, in relation to the definition of harm, could you look at what the Justice, the Justice Bill has brought forward in terms of definitions of harm? Because while the amendment does go a bit further, in my opinion, it still isn't definitive in terms of, I think in that bill, it actually said that people didn't necessarily, or children didn't necessarily have to witness or hear, but the impact of domestic and violence and abuse was transferred to children through transgenerational trauma. So if we could ask if you could just do that by way of comparison, it would be helpful. So, Chair, my second point is in relation to, so I do appreciate that there is a time scale in terms of bringing forward the amendments for clause by clause consideration. But I would ask that in the case, while it doesn't say in the current legislation that once you're over 21 that all contact stops, but in the custom and practice that once a young person's 24, and if they're not in further education up until 24, then the contact becomes intermittent. And we heard that from some of the young people who came through care and who were now studying. They felt that even in relation to going the extra mile, that wasn't the case, and it was sporadic across the board. And I think it was the Western Trust, I don't want to be misquoted, so I'll just put a caveat in that, said this was resource dependent. So if we could have a look at that, and then even just in terms of, while it said there'll be a 6-month review, in what format will that review take place? Is that just a matter of good practice, or will it be a statutory review? Will there be an annual review? What form will that take place? Sure, I'll just leave it there because I appreciate we have a lot to get through.
And just before you come back in, Eilish, if I could just ask, there is a kind of a buzz on the line. I thought it had subsided a bit there. It's like a fan or something. Or maybe it's a fan within someone's device and there's nothing can be done about that. But there's a bit of a buzz in the background noise. If anyone has anything going, they can identify. Please see if you can. But otherwise, we'll turn on. So I'll go back to yourself, Eilish.
Okay, so on Carol's first point then about the definition within the Domestic Abuse and Civil Proceedings Act, I mean, that was one thing that we did consider. We looked at the definition. We instructed Council on the basis of that definition, and Council is of the view that, Carol, this is probably the best way to amend the definition. I think what we need to be careful of here is that we don't dilute in any way the principal purpose of that definition, which is about the direct harm to a child. So it does now include a child being present when domestic abuse takes place and not having to see it or hear it. So on the basis of Council advice, we consider that that's probably sufficiently broad and inclusive, Carol, and probably the best way to deliver the definition. In terms of your second point then about children who have left care and maintaining contact with them, there's an important provision within the bill, probably the most important, if I'm perfectly honest with you, and it relates to maintaining contact with children over the age of 21 if they are not in receipt of advice or support. So the duty is actually to make contact, to make an offer of advice or support, and to continue to make that offer on a yearly basis until the child until the young person is aged 25. So I think that's critical and provision within the bill. In addition to all of the other measures that we've put in place for care leavers. So I hope that assures you to some extent. The review that you've referred to is pathway planning and review that the current legislation requires to be undertaken on a 6-monthly basis. We haven't made any changes to that, Carol. That will continue to be the case. I'm going to put my hands up and say that is not without problem. There are some issues with that, and one of the things that we're also proposing to do, or the Health and Social Care Board is planning to do, is to undertake a review of leaving and after care services that will actually look at things like operating models, how they plan, etc., and look at demand and capacity issues currently within those services, and that will, based on the outcome of that review, there's the potential, for further changes, etc., to be made. So I think quite a lot within the bill and outside of the bill happening, designed to support a better support children who've left care.
Okay. Then on the other issues, Eilish?
Sorry?
There were some other issues, were there, Carol, you had raised there in your questions?
No, it was just in relation to the pathways review was 6 months, but even just in terms of the overall bill, sorry, I didn't make that clear. In the implementation of the bill, will there be an annual review, and will it be done on a statutory basis?
A review of how we are implementing, Carol, is that? I think that's integral to implementation. So we need to continuously. There will be an implementation framework put around all of this, if we can just describe it in that way, supported by implementation plans, etc. And we will keep those plans under review and subject to monitoring to ensure that we're keeping to the plan and to that three-phased approach to approach to implementation that we've already referenced. Does that answer your question?
Okay, so I will then move on to Pam Cameron, Deputy Chair Pam Cameron. Go ahead, please, Pam.
Thank you, Chair, and thank you, Eilish, and the panel for your attendance at committee today on what's a very important subject, and it's obviously a very large and quite a complex bill, so we do appreciate your attendance today. Carol had asked around the definition of harm to a child and bringing this into line with the domestic abuse legislation, and that's constructive, that's good. So I'm just looking a little bit of clarity. So you're saying you did get legal advice around that wording, and if that's the case, have you also spoken to the sector who are concerned to see that the wording is meeting their needs, that they're confident that actually deals with that issue? That's my first question. And another question for you, I wanted to ask around the department's rationale for not going further in relation to amending the bill in some areas, relying on powers to make regulations addressing these points. I wanted to ask what assurances the Minister can provide that the consultative process for the development of those very important regulations, that it will be accessible, that it will be far-ranging and inclusive, especially given the effective yes/no function afforded to the Assembly within the process. And I do understand that it's a very large bill, and there will be much more detail to follow in regulation. So it would be good to hear how that will be done in future months and years going forward, given how important this particular subject is.
Okay, so I've already made the point that, Pam, that we did fully consider the domestic abuse legislation when deciding how best to amend the definition of harm within the children order, and the clause that we've got is the clause that Council is recommending is the best way forward. I don't think that we've actually shared the amendment to that clause with any stakeholders, and Pam, we're very, very happy to do that between now and when the clause comes to committee. And then on your third issue, our intention would be to be as inclusive as possible in implementation. Certainly that was our approach to the development of the bill. We did have a stakeholder group, for example, established, and they were consulted every step of the way. That would be our intention as part of implementation too. And I just want to provide you with an assurance on that particular point. And it will include obviously children and young people too, and parents where it's relevant to them, and carers.
Eilish, that's very useful, thank you. And I think it would be very much appreciated, both in terms of the sharing that the actual wording of the amendment in terms of the definition of harm to that sector, to get their feedback. I think that's really important. And also thank you for your reassurance on going forward with the regulations, because I think that is vitally important. I mean, the sector is obviously desperate to see this legislation come into effect, but we all understand that there's an awful lot of detail missing from it, and that will form regulation. So that process of engagement with the sectors involved is vital. So thank you for that. Thanks, Chair.
Thank you.
Okay, thank you, Pam. And going then to Paula Bradshaw. Go ahead, Paula, please.
Thank you, Chair, and thank you, panel, for coming this morning to committee. I've a couple of issues that are sort of related to the amendments, but they're just issues that have also come up in some of the evidence sessions and come to me. So apologies if you don't have the answer, but I do want to raise them with you. Well, the first one really is around the access to the adoption records, and I really welcome the movement in that regard. I note in the last 24 hours in the south, they're bringing forward the Irish government bringing forward the Birth Information and Tracing Bill, and what they are allowing there are for adopted people the automatic right to access their birth certificates and access to information about their early life from the age of 16. And I think in this bill we are looking at 18 for that process of application to see your birth certificate to start. And I'm just wondering, to what regard are you going to look to what's happening in the south? You know, people do move either side of the border for work and for other personal reasons, and this may come up as an issue in the future. So the second part of that is around the access to early life information, and this came up very much with the adopted parents in terms of how they can settle their children, certainly through transition periods, just say they're starting P1, you know, how they tell their story, how they are aware of themselves. And I think they felt that there was deficiencies, or certainly postcode lottery, in terms of support for them as adopted parents for how they can work on this life storybook process. So I just want to raise those two issues. The other one, I don't think is within the scope of this bill, but again, I want to raise it, and that's the cliff edge that some foster parents are experiencing, those people who are self-employed. So, and again, they really wanted to stress that this was not about the money, but it was about financial security as such, that if you're a foster parent, you receive an allowance or money to cover costs, and as soon as you become an adopted parent, you no longer receive that. And if you're self-employed, the last thing you want to be doing in those first few weeks or months when you've just received a child or children into your home is then to be worried about financial implications and scrambling around for extra business or part-time work. I think that's a time when they shouldn't be worrying about financial security. So it's just that cliff edge that they raised, and they were embarrassed, but I think that nobody should be embarrassed in the situation, because we want to give the children the best start they can when they are moved into adoption. The last issue I want to raise is around the special guardianship orders. And I have had constituents who've come to me who were given an order to look after their grandchildren, for example, and their own child has died, but the father has then applied to change the contact arrangements. Now, this was an order of the court prescribed by the social worker, but whenever the father kept going back to try and change the contact arrangements, it was up to the grandparents who were retired to cover the legal costs. So they're up into mid-teens of thousands of pounds because they have to keep challenging what the court has said every 2 years. And I'm just wondering around the costs for when the parents who've had the children removed can challenge any orders, how the people who are actually looking after the children can be supported financially and practically as well by the state, because effectively they're seeing out their orders. And I hope that makes sense. But I just want to raise those issues, and I'm not sure whether you have a response now, but there's certainly things that are on my radar. Thank you, Chair.
Thank you. Yeah.
starting with your first point, Paula, about the legislation being brought forward in the South, the information and tracing bill. I mean, we had a look. I mean, this was only published yesterday, so and we did have a look at it, and we did note the age difference in terms of access to birth information. The point that I will make is that access to birth information has been in place here for a considerable period of time. So this is not being introduced by way of the Adoption and Children Bill. It has been in place. I'm not quite certain why in the South they've decided that they're going to alter the age to 16. We look at that, and Paula, to see what the thinking is behind that, and whether there are any differences between the two jurisdictions that actually justify that, or maybe even require it. The second bit then about access to early life information. I mean, I may ask Frances to come in on this point. But that is part of the process of getting access to your adoption records, for example, so your early life information will be central to that, and there are support services and everything in place to assist with some of that. I'll let Frances come in a minute if she has anything to add on that particular point. On the cliff edge point, Paul, a couple of things. In my understanding is that a foster carer who becomes an adoptive parent, certainly the option of getting an adoption allowance in place of a fostering allowance is there. Now, why it may not be happening in all cases, if that is the case, we would need to look at to see why that is the case. The other point that I would make is that with the introduction of an SGO, that may be another route for foster carers, all subject to their own decision making. So while some foster carers can only adopt at the minute, in the future, an SGO will be an alternative route for them to obtain parental responsibility and other things for the child in their care. And then on your last issue, Paul, I would need to look at that in more detail to see why that is the case, and whether there is anything that can actually be done about it. It doesn't seem quite right to me based on what you have described, but it's certainly something that we're willing to look at and maybe provide some advice to you in writing on that particular point.
I appreciate that, and obviously it's a very sensitive case, and I'm happy, Eilish, to engage with you in finer detail outside the committee, because I do think we have an opportunity to address it, and as I say, there's a lot more detail to it, but it's certainly around that challenge in the courts. I suppose the issue, what was the other? I think you've got it.
Paula, maybe can I just come in there in relation to contact for SGOs? When making a special guardianship order, the court will have the power. It's actually required. The court will be required to consider whether a contact order should also be made at the same time as the special guardianship order, in order to provide clarification around the contact arrangements going forward. So, whereas possibly what the current order was about was maybe residence order or something along those lines, an SGO, the court will have the power to set that all out and clarify the position. And then we have funded for mediation to be provided by trusts in relation to supporting those contact arrangements post the making of an SGO. So give some reassurance.
Yeah, I suppose it's the years later, Julie, when the children are maybe, again, I don't want to labour it, but, so at the time they may be happy with it, but, at the passage of time, might say, actually, I'm no longer happy with meeting them in a contact centre. I want them to be able to come to my home, for example. And it's that years later that, this spectrum, this could be challenged at any time at great costs.
I mean, I will just come in a bit there, Paul, on that we really envisage the availability of support in terms of both, for special guardians as well, that will be ongoing, so that the discussion about those situations hopefully will be easier and will be available, because the support will be throughout, the child or young person's childhood. So we're really hoping that will strengthen the support that those kind of parents, grandparents would get. And reflecting back, I suppose, on the question really from maybe adoptive families and the information, I mean, we're really hoping that with the introduction of the bill, it's going to be much more clear what information that they must be given at the time of placement is going to be prescribed. And they're also going to, we're going to hope to prescribe as well, but this will be the detail will be in regulations. Later life letters and also life story books must be available. So, we're really hoping that will strengthen, the information and the regulation around the information that adoptive families should get.
Thank you. Thank you.
Thank you, Paula. And going then to Orlia, and that's I'll just ask the clerk to check, but that's the last indication I have at this point in time is from Orlia Flynn. So Lana, Orlia.
Yep, Gormiagat column, and thanks very much to the officials for coming along today and for briefing us on this issue. I want to just bring it back to the Clause 5 and the support services and the decision not to amend that, putting the duty onto the trust to provide those services. So my question is really around, Eilish, in your briefing you had mentioned there around that you're allowing this initial flexibility for the trusts to use their discretion whether to decide after someone's had an assessment if they need support. So just on that, does the department know how long that initial flexibility will run for? And is anyone from the department having any sort of oversight alongside the trusts in that process of that flexibility?
Okay, earlier, so this kind of feeds into Carol's question about implementation too. So this will all be part of implementation of the bill. So monitoring of what support is provided to who will be part of the implementation arrangements, and that will all be led by the department. The department will not be part of it; it will be led by the department. I would imagine that we would need to let things run for at least a year, maybe 2 years earlier before you start to make decisions about whether or not you need to prescribe categories of person in regulations. But just to assure you that will be part of the ongoing monitoring that takes place under implementation of the bill, which is the point that Carol raised earlier.
Yeah, no, and I understand that, and I suppose I'm just trying to think how it might be helpful to, because the fact that the clause isn't being amended to put that statutory duty onto the trusts, then, could we be more specific or more detailed around then how long you expect that period of flexibility to run? And the only reason why I'm saying it is because I know that it's saying that, so obviously then you're giving the trusts that discretion to decide where the support is needed, but it also says that that's on the basis of need and on the availability of services. So what my concern would be is that, in certain areas, if services aren't locally available to the trusts, then are some families and individuals going to be at a disadvantage to receiving that kind of support? And that's why I think that issue around that flexibility with the trusts, the time period, I think is quite important. So I do accept then that obviously that will be captured then within the process of the review that you're carrying out, and not where you're keeping it all under sort of observation. But the second question around that, Eilish, was see in relation to that the capturing of the range of adoption support needs. Has any of that work, was any of that work not carried out up until now in the run-up to the formulation of this bill? or is that really only starting now then when you're working with the trusts around this initial flexibility period?
Okay, so and taking your first point again then about the potential for services not to be available consistently across the region. You need to bear in mind another duty within the bill. There will be a duty to provide certain services on the face of the bill itself. So for example, counselling will be required to be provided. Advice will be required to be provided on the face of the bill. But there's also power there then within regulations actually specify other services that must be made available, and that will be obviously across all trust areas. And Julie has referred to some of those services earlier on, including things like therapeutic services or services to facilitate contact or to prevent adoption breakdowns, etc. So you need to read this in conjunction with other duties that the bill actually creates. And I think when you're monitoring, Orlia, you will be able to see very easily what is being provided, where those inconsistencies actually lie. It might be something that we could come back to committee with at a future point in time. Once that monitoring is undertaken and what the outcome of that is and what it's telling us, we could come back to committee on that at a future point. And in relation to your last question then about the range of adoption support needs, yes, absolutely, that was undertaken. In fact, it was necessary to be undertaken to be able to cost the bill. And for example, so again, an assurance it was done. Whether or not the range of services changes over time, it is another matter. And again, that is something that will need to be kept under review. But we think we've got a pretty broad spectrum of services. Number one, that we will require to be in place, and number two, then the funding to be made available for them.
No, that's great, Alicia. Thanks very much. And then just finally, one of the members who touched on, it might have been Carol, I think, just around the implementation framework. So once the bill is passed, I'm just wondering, when does that process of work start with the department, where you actually start planning out that framework? Do you need to wait until it passes, like officially at the Assembly, to start designing what the framework will look like?
The initial design work has already taken place, so again, this can be provided to committee if you want it, but the phasing work has been undertaken. What is going to be done when, and Julie has given you some examples of what will be done immediately and what will be delayed until year 3. So thinking has been done, and that obviously needs to be developed further, with very precise timescales put against individual sets of regulations, etc. But that's all part of the implementation process. Julie will be starting that right away, Orlia, as soon as this bill gets royal assent. She'll be delighted that I've said that and committed her to doing that.
Oh, no, that's great.
I actually already have a member of staff already starting to look at the early regulations that would be needed for the transitional adoption support regulations, because we appreciate that we'd want to bring those ready, as early as possible in the new financial year next year. So some of the work we're already starting to scope out.
Yeah, no, that's brilliant. Thanks very much for that. And I suppose it would be useful if the committee members are in agreement, if you could share that information, the work that has been done up until now around the implementation framework, and then down the line how that observation goes with the trusts in that flexibility period. That would be great to see any of that additional information. Okay. But thank you very much.
Thank you. And Alicia, actually, I think it is your device that's creating that feedback. It's probably an internal fan. Your device is just probably so hard worked that it's coming to you. Might be looking for a repair shop or a new device soon, but if you can stay on mute when you're not contributing as much as possible, Alicia, that is helping. I just wanted to I just wanted to pick up on that issue around the complexity and the extent of the implementation and the critical nature of that. And this is clearly a massive bill, and any health committee ideally would love to have longer period of time in relation to the scrutiny of it. Although we have also heard significant evidence that the bill is so long overdue that it's important that it progresses as well in support of the children that we're talking about. But is it possible that we could build in a statutory review, an annual review, so that implementation can be tracked by a committee or by whoever? I think that's the case with the children order, maybe, that there is an annual statutory review. So is that something that would be possible within the terms, rather than just saying we're going to develop these things after we start implementing them? Can that be done on a statute and put it on a statutory basis, where there would be an annual review on a statutory basis of the implementation?
Colin, that's something I would like to take the view of council on the children order provision that I think that you're referencing is a requirement to produce an annual report. Maybe not the same thing. Colin, if you don't mind, let us take the advice of council on that. I don't know how unusual or otherwise that is within legislation, but we'll note it, we'll seek advice and come back to you.
Okay, that's fair enough. So I'm going to go to Colin McGrath and then a quick point from Carol, and then I think that's us about finished. So Colin, go ahead, please.
Thank you very much, Chair, and thank you for the presentation. Yeah, I think maybe that implementation phase is something that's going to be quite critical. We met with, for example, parents there a number of weeks ago, and we were hearing lines like, you have to fight for everything that you've got to get. It's the charities that are providing the support, but they don't get the information. There's a lack of continuity amongst the sector in terms of having 4 social workers across the time that they're working. The fact that there's a lack of trauma awareness. There were significant concerns on the ground about the processes that were being delivered. And I suppose maybe if you're looking at that implementation phase, it would be good to hear how you intend to engage with the sector, to hear what the problems are on the ground and the problems that people are facing, and then how you can implement this bill to actually address those, because that's what adoptive parents and potential adoptive parents are actually looking for. They're looking for the sort of the hope that this bill will actually address a lot of the issues and concerns that they've went through. And I would also echo again the remarks about the financial assistance, because that was something that came clear, that there was that sense that if you foster, you get lots of help and assistance. If you move to adoption, then it stops, and that there could actually be a barrier to some people actually taking on the role of being an adoptive parent, and that actually would be counterproductive to what the process is trying to do. But there were 2 other issues that were raised, and I was wondering if you could let me know how you feel that the bill actually addresses them. The first is there was concern about the lack of connectivity between education services and adoptive children, whereby there is lots of evidence that they are significantly underachieving comparing to their peers. And in some other jurisdictions, there's actually within there are systems, there are grants that are available to provide additional assistance and support for young people in their education, which would try and help to address that imbalance. So if we maybe just get some thoughts, if there's any clauses within the bill that would help to address that or allow that to open up in the implementation stage. And another message that came through was the clear regional disparity between trusts, where one trust will deliver a service and meetings happen every couple of weeks. In another trust, it could be every couple of months, and that people were having different experiences depending upon where they were regionally. And if there is any scope within either the bill or the implementation to try and address those issues. Thank you.
Sorry, Ellis, you have to come off mute now. I know you're only doing what you're asked, but you're still on. Yeah.
So coming to your first general point, I think we've already given the commitment that we will be as inclusive as possible in terms of implementation, and implementation will not solely involve trusts or voluntary adoption agencies. People who are users of services, etc., will be central to and critical and to implementation. So again, that's a level of assurance that I'm trying to give. On the education point, then, two responses to that. I mean, it's one of the reasons why we brought forward a strategy jointly with the Department of Education for looked after children. I mean, that was recognising just how poorly some of them do in terms of educational outcomes, and that strategy is now in place and is in the process of being implemented, and it's fully supported by both departments, Colin, Health and Education. I mean, there are some payments already in place within Education for looked after children, for example. So there is a pupil premium that applies to a looked after child, and we put other measures in place recently. So working again with the Department of Education through a transformation programme. There is now a looked after children champion, and within education, so that is all done on a joint basis at the departmental level and also at agency level. A couple of some provision within the bill then specific to education. One is a duty on the part of trusts to promote educational achievement of looked after children, and then there's a second provision there that is intended to ensure that a trust, when it's making a decision about where a child will be placed or where they will live, that they don't unnecessarily actually disrupt that child's education in the process. So they're two very distinct pieces of provision within the bill relating to education. In terms of regional disparity, some of what the bill intends to achieve is consistency of provision and delivery across the region and within and across trusts, Colin. And again, it comes back to the implementation point. A good implementation arrangement and framework should begin to expose some of that disparity if it exists and continues to exist in the future.
Thank you. Just two wee small points on that. This is my own lack of understanding, so it's just to help me. But in terms of LAC children, as they're called, the LAC, is that, would a child that's adopted be considered a looked after child, or is that definition changed whenever they actually become adopted? That they're no longer a looked after child, that they're defined as does that change? In other words, are they not able, as an adoptive child, to be able to avail of those looked after children funding streams? And then just a comment on the educational achievement. I think we've had presentations where we do have some concern about the word promote, because promote can be, hey, get out there and do great. That's not necessarily what may make the difference. It may mean a lot more than that. So it's tightening up the language around the word promote. But that's a comment. But just that question about whether adopted children are considered looked after children for availing of those grants.
Okay, so an adopted child is not a looked after child. At the point when they become adopted, their looked after child status falls away. But you're quite right. The majority of children who are adopted now actually have come through the looked after children system. It's why, for example, we have certain support services in place within each of the trusts that are targeted not only at looked after children, they're also targeted at adopted children. So each trust, for example, will have a therapeutic service for looked after children and adopted children, and it just recognises that those difficulties that they may have had while looked after haven't fallen away when they are adopted. That pupil premium that I've referenced doesn't, to my knowledge, actually apply to to adopted children, and I think it was something that we tried to do a number of years ago. We tried to using that word promote again, the Department of Education to apply that premium to adopted children, but I think the decision was made not to do it at that stage. I don't know whether Julie or Francis want to say anything else about other services that are provided to adopted children. I'm thinking about TESA, for example, that provides training against schools for so that schools are aware of adoption and what adoption means and the trauma that might be associated with children who are now adopted. So there are a number of measures in place, Colin, that are intended to support adopted children who have been through the looked after children system.
I could just add that certainly in relation to some of that support, we have costed on the basis that funding will be provided to allow that to continue for adopted children going forward under the bill, such as Tessa. Also, coming out of consultation, we received quite a number of suggestions around educational issues that weren't within the scope of our bill or within even there was something that the Department of Health could actually legislate for or make decisions on, but we did share those with the Department of Education, and I understand that they will be sort of considered and kept under review going forward under anything, any joint working between the two departments.
And I suppose the only other thing to add, Colin, is that the strategy that Eilish has referred to, the joint strategy with between health and education, also covers children who've been previously looked after, and obviously the children who are adopted have been previously looked after. So it is a way of fitting them in to that system as well.
Thank you, Colin. And Carol, a brief point to Carol you were looking to make, and a clarification, I think it was it, or a question?
So it was yeah, thank you, Chair. It was a clarification really on, so in terms of getting access to records, I understand that the Irish government has taken forward legislation to ensure that people have access to their birth certificates. But when it comes to the mother and baby homes, there was a decision made previous that all the records were closed. So the question I would have is, if someone who was born in 26 counties but was adopted in the north, will they have not only access to their birth certificate, but will, ensuring that openness and transparency be applied to their possibly being born in a mother and baby home and the whole adoption process thereafter?
Yeah, Eilish?
I think it's wrong to suggest that access to records is closed, Carol. That is not the case at all. I think I've heard the word sealed used in connection with adoption and records, and that is absolutely not the case. The intention, and I think this will become clear in the guidance that is under development at the minute. The intention is to ensure that adopted people have as much access to as much information about themselves as is possible to give, and to ensure that there's a supportive process built around accessing adoption information for people who do want to access it. So I just want to make the point that the closure of adoption records is not accurate, Carol, and we're currently working through a process of ensuring that adopted adults, regardless of when they were adopted, have access to as much information as possible in a very supported way. I'm not quite certain what point you're making about the movement across the border. I did note that there is some provision within the legislation being brought forward in the south that enables agencies there to actually make contact with other states. I think it is how it is described. Again, we looked at it very quickly yesterday. I do want to have a look at that in a bit more detail and see if there's comparable provision, I suppose, that could be included in the bill. But you'll appreciate that we're rapidly running out of time with this. But it is something that we've noted and we will look at, Carol.
Yeah, there was massive criticism, Eilish, when the Mother and Babies Homes report was made in relation to the handling of the archives. And so I want to make the distinction between the handling of the archives of the Mother and Baby Magdalene Laundries report into the adoption process. I want to make sure that when it comes to the adoption process, that access to all that information and records is seamless. And that's what I'm hearing you're saying. But there were issues in relation to the Magdalene Laundries stroke mother and baby homes in the south.
Okay.
Yeah, okay.
Go ahead, Eilish, yeah.
No, I mean, there absolutely were issues in the south, and we followed what has been happening in the south quite carefully and closely. The issue that you're referring to relates to the records actually created by the Statutory Commission of Inquiry. In the south, access to individual adoption records is a completely different matter, Carol, and that's what the adoption. The information and tracing bill in the south is now intended to deal with. I think we have been more advanced, if I can put it that way, within the north in terms of how we deal with the issue of access to information. Do we need to do better? Absolutely, we do, and that's partly why we have introduced amendments to clause 102. Under the bill and removed that requirement for somebody adopted before 1987 to have, to engage in counselling before they can get access to their birth certificate information. It's also why we started the work on the development of guidance. That again is quite advanced, but there are some important issues that still need to be resolved as part of that process. So. We are making. I think we were in a better starting place, if I can put it that way, from the south. We are making further developments by way of changes to the bill, and I think there is more to be done in terms of the production and issue of guidance to adoption agencies to ensure that when somebody does want access to the records, that it happens and consistently, and they get access to as much information about themselves as is possible to give.
Thank you, Eilish. The other issue that I wanted to touch upon there and has been raised within the session as well, and I wanted to come back to it, was around the issue about cross-border and grandparents were mentioned earlier on in relation to SGOs. I am aware on foot of a previous session that the Human Rights Commission are looking at that issue and what the implications may be. Have the department done any further work in relation to that issue in terms of, or is there anything further that you're considering to address that issue, whereby family members, and where I live here and where I am, I know very many people whose grandparents could live on the other side of the border but only be a couple of miles away from them, and obviously an important part of their life. So, has there been any progress made from the department in relation to that issue?
Colin, if I'm absolutely honest with you, I'm not fully aware of the issue that we're trying to resolve here. I mean, we have made the point that, for example, a protocol is in place between social services north and south that actually governs how agencies north and south will actually work with children and families who either move across the border or in circumstances where a child is placed across the border. And those arrangements are very clearly set out within that protocol and who will do what and what is expected of who. So I'm very happy to share that protocol with you, Colin, if you think that would be helpful.
Well, that would be helpful. The issue is that we have been told previously that an adoption to the 26 counties should it be the best in the best interest of the child would be handled under inter-country rules and the Geneva Convention, which are much more complex than the rules we're talking about for other. So what I'm saying is that children here could be disadvantaged as a result of additional bureaucracy. That's the issue, for clarity.
Okay, so on that issue, nothing further has been done. I mean, you're quite right. A child who is adopted in Northern Ireland from the south would that would actually constitute an inter-country adoption. That's set out in international law. Column it would require, I think, a change to international law to make it happen differently. Now, the only other thing that I can think of in relation to adoption and cross-border cooperation is on the access to information point, whereby it is easier for an individual whose adoption journey may have taken them across the border to get access to information about them. There might be the potential to put in place a protocol, I suppose, similar to the one that I've already referenced to, that is specific to child protection or the placement of children across the border. So we haven't done anything further on that column.
Okay, well, and indeed, if international law requires to be changed in recognition of the realities of life for children here on the island of Ireland, then so be it. And I think in terms of the Good Friday Agreement and the protocol, all of these things need to be considered. I'm not sure how they intersect with this bill, but clearly, hopefully, we'll hear some more information in relation to that in terms of the evidence. But it is an issue that I think we need to streamline and open up that potential in the interest of these children. The other thing I want to just leave you with maybe actually is a couple of messages from the session that we did with children, just to amplify their voices a little bit, and also to reflect on the fact that both with the parents and the children, there was a lot of talk about the inconsistency across practice. Some very good examples, and someone said that some homes are doing life skills really well and others don't bother with it at all. So you get messages like that. There were also some messages, I have to say, concerning around inconsistent social work practice, and indeed some examples of poor practice were mentioned. And I will raise that at the first opportunity with those who are involved in that. But I think it's important that we bear that in mind. But two of the things that I wanted to flag up in particular were one of the young people went to a course in England, but all of her support network were here. And she said that she felt that the authorities or the trust were, and to quote, ready to close her case without a second chance because she was now in England. So I think that needs to be considered if young people are travelling across these islands, east, west or north, south, that the supports would follow them in whatever way works for them. The other thing, and I think it was value in young people's expertise was a theme. And there was one thing that was said that I think was really quite profound by one of the young people, and it was that around the issue of having options. And he said, when you have an option, you have a voice. And I think that's a really, really profound statement. And I just think it's worthwhile, all of us, yourselves and ourselves, considering as we discuss this issue around how we provide those young people with options and give them meaningful options and discuss them with them. So I wanted to amplify their voices to you. The other big message, or very important one I thought coming out of that, was that leaving care is not an event. I know some of the young people said this. It's not an event, it's a process, and they need to be supported throughout the process. So I just wanted to sort of raise their voices on their behalf, and indeed to thank them again for sharing their voices with us, and I'm sharing all to you. So do you want to say anything in closing, Eilish, or are you content then?
Mute.
You're on mute, Eilish.
Done it again. I mean, there's one thing that I should have referenced, and thank you for prompting me to do it. In terms of the inconsistency of practice issue, and maybe poor practice also that you've referred to, and I have indicated this to you before, Colin, the plan is to undertake what we're calling a fundamental and independent review of children's services here in Northern Ireland, and that review, everything going according to plan, should actually start at some stage in February. The Minister's intention is to advise the committee about the review and what it intends to achieve and what it will look at and who will be involved in it, etc. That information should come to committee hopefully before the end of this month. and there will be obviously an opportunity for the committee to be kept informed and advised of that review while it's happening, and also when it concludes. And central to that review column will be the voice of not only of children but also of parents. So there will be mechanisms put in place as part of that review to engage children and young people in the review, and also to engage their parents in the review. And that's parents who may have had experience of child protection services, their children may have been taken into care, their children may have been adopted, for example. But more information on the review will be with you in the not too distant future.
Yeah, and I'm delighted, and I welcome that. I think that's a very important piece of work. And I know you've reflected this as well, but just to reiterate, the fact that it's not just individual practice, but it's structure within the trusts, variations across trusts, as well as variations across individual practice. And as I say, some good as well, some really good examples. And what we clearly want to do is develop the good examples and roll those out across and reduce and minimise those poorer examples. So I want to thank you all for your extensive engagement here this morning. It's been quite a long session. This is a complex bill, and I want to thank you for attending the session today, and to wish you all the best in the time ahead, and indeed a happy new year to you all for the incoming year. And thank you. Okay. Okay, members.
Yeah.
Okay, thank you. So, members, we will be returning to deliberations in relation to this. So, we'll be coming back to this. But for now, I propose that we take a break there. We've been going for some time now, so I'm going to take a brief break there, and I think we'll come back at 12 o'clock. So that's about a 14-minute break, members, and resuming again at 12 p.m. Thank you. And Claire, could you just advise when we're off the public session?
That's us now, Chair.
Hi, Keith. Are we back on? Okay.
Yes, we're back on. Colin, your camera's off at the minute.
Okay. So how's that? You still hear me okay?
Yes, that's spot on. That's us live again, so ready to go.
Okay, thank you. Okay, thank you, members. And the next three agenda items, members, are statutory rules relating to coronavirus. Department officials are here to brief the committee on the provisions of the SRs. I refer members to the clerk's memo at tab 8.1 of the pack and copies of the SRs at tabs 8 to 10. I would like to outline, members, that SR 350 was laid in error and should have been SR 349. A copy of SR 349 is included in your table packs at tabs 10.3 to 10.5. Members should note that there is an error in SR 349 that states the date it was laid in Parliament. This should have read that the date it was laid in the Assembly, and we are waiting for a correction slip to rectify that error. Members, I would also outline that the Examiner has flagged up some issues to the Department in relation to SR 348, the wearing of face coverings. So I now welcome by Starleaf, first of all, Elaine Colgan, who's Head of Protection Branch 2 in the Department of Health. Good afternoon, Elaine. Can you hear me okay?
Can you hear me okay?
Yeah, we're hearing you okay, Elaine. Yeah. I think there was just a slight delay in bringing you up into the spotlight, but I'm seeing and hearing you clearly there now, so thank you.
Great.
Also, Niall Donnelly, who's Deputy Principal in Health Protection in the Department of Health. Can you hear me okay, Niall?
Yes, Chair. Can you hear me okay?
Yeah, hearing you there, Niall. Thank you. David Hughes, who is Grade 5 Health Protection Legislation, Department of Finance. David, are you hearing me okay?
Sorry, Chair, we seem to have lost David. We'll try and get him back on and in when he gets back on.
Okay, so we move on then and check with, do we have Jane Holmes? Jane is Head of COVID Strategy and Recovery Branch in the Executive COVID Task Force. Jane, can you hear me okay?
Yes, Chair, I can hear you. Can you hear me?
Yeah, hearing you loud and clear there, Jane. Thank you. So
thank you.
that's everyone in place. Hopefully, we'll get David before he's required. And I'd like to welcome you all to the committee this afternoon. Thank you for coming along and briefing the committee on these SRs. So, Elaine, I'll go back to yourself then, if I may, and if you could go ahead with your presentation or outline how you're going to deal with the presentation.
No problem. Thank you, Chair, for the invitation to attend today. Today we are considering 3 statutory rules, and just with the period of leave, that's why there's so many of us here today to cover them. So we'll each take the relevant amendment. I will begin by briefing on amendment number 20 made on the 9th of December. And then I'll hand over to David, who I can now see has joined the meeting, and hopefully we can hear him as well. But I'll hand over to him for amendment 21. Made on the 23rd of December, and Niall will then brief on the 3rd SR, which is 348, number 8 amendment to the face covering regulations, and that was also made on the 23rd of December. So firstly, amendment SR number 334, which was amendment number 20. It makes some changes to the regulations regarding COVID status certification, and that was largely as a result of stakeholder engagement which took place during the 2-week grace period following introduction of certification. So the changes were as follows: the removal of the definition of active period, which was simply a tidying up exercise that Department of Finance had requested. We amended the required time frame for the negative rapid antigen test. It had previously been 48 hours before the event or entrance into the relevant premises. That was amended to the same calendar day or the calendar day before, and that was simply to align with how the NHS reporting system works. There was a removal of the requirement to provide photographic identification if the evidence itself provided for certification included a photo, and that was simply to provide clarity that if you use the domestic COVID certification app where the photo is on the screen, you don't need separate photo identification. And we also reworded entirely Regulation 16E to ensure greater clarity on the original intention. The original drafting included some long sentences without punctuation, and depending where you put the punctuation depended how it was interpreted. So a number of stakeholders had interpreted it differently. So we were just absolutely clear and reworded it entirely to make sure everyone understood the requirement. Some further minor changes were made to the wording to clarify who was responsible for a relevant premises or event, where the premises owner themselves may not actually be involved in organising the event being held there. And a requirement to have a system to verify certification is in place for all those who enter the premises at the point of entry. So I just would like to stress that there was none of the changes made in this amendment were policy changes, so there wasn't an executive discussion as such. They were all bringing previous policy into line and just clarifying wording as a result of stakeholder queries. So if David's able to partake okay, I will hand over to him for Amendment 21.
Yeah, go ahead, David, please.
SR 2021 number.
David, we're not hearing you. Sorry.
On relations.
David, just sorry to interrupt you, but we weren't able to hear you there. Just start again, please. I'm not sure if you're back online now.
Can you hear me now?
Try it again. Yes, I think we're hearing you now, but we're crossing. I think there might be a delay on the line, but I think we're hearing you now. So go ahead and start again, please. I'll indicate if we're not hearing you.
Okay. Right. So this set are the SR 2021 number 301 regulations.
No, David,
okay.
We're not.
These
were
not
not
made on the 23rd of December.
I
David,
think
we're not
Chair,
hearing you.
Chair, would
I'll
it
go
be
back to
helpful?
it.
Yeah, if I'll just, I have David's briefing, so I can read the briefing. Hopefully we'll be able to get David for questions. So SR 349 was made on the 23rd of December. Regulations 7A, 9, 14 and 18 came into operation on the 26th of December, and the remainder of the regulations came in on the 27th. The amendment made the following changes. It reintroduces the requirement for customers to be seated in hospitality premises and sets out the same qualifications as before: entering or exiting the premises, accessing a table, making a payment, placing an order for food or drink in the case of unlicensed hospitality only, accessing a buffet or carvery, accessing a toilet, baby changing or breastfeeding facilities, or a smoking area. The amendment sets out a similar requirement to ensure customers are seated in theatres, concert halls, conferences and similar venues. At the same time, it places a restriction upon indoor standing events, with exceptions for funerals, weddings, civil partnership registrations and communal worship, religious worship. In the hospitality sector, it reintroduces a limit of 6 people at a table when from more than one household, or 10 if it is one household, not including children 12 and under. It also places a legal responsibility on shops and retail to ensure that risk assessments are carried out and all reasonable measures are in place to reduce transmission. It places a requirement on office premise owners to have reasonable measures in place to comply with 2 metre social distancing. Prohibits dancing indoors in hospitality venues, with the exception for dancing at an event to celebrate a wedding or civil partnership. It requires nightclubs to close, and it also inserts some necessary definitions of shops and offices to make relevant internal references within the regulations. So I will hand over to Niall, who will finish the briefing with the face covering amendment number 8.
Thank you.
Thanks, Elaine. Thanks, Chair, for having us this morning. So Amendment 8 to the face covering regulations was made on the 23rd of December, and it came into operation on the 27th of December. It made a number of amendments. So first of all, it amended the list of reasonable excuses to not wear a face covering by removing the provision for severe distress. So this has been replaced by an onus on the individual to provide proof of exemption on medical grounds by way of disability within the meaning of the Disability Discrimination Act of 1995. Enforcement for this provision was originally due to be delayed until the 7th of January. However, that has since been extended as work is ongoing on the enforcement scheme. The amendment also removed the requirement to wear a face covering when in the outdoors area of a transport service premises. For example, it had been the case that a face covering was required on a train halt, regardless of any other individuals present. So this provision removes that requirement. And finally, it makes a minor amendment to the requirement to wear a face coverings on a ferry. So on the outdoors area of a ferry, it had previously been the case that there had to be 2 metre social distancing in place before a face covering could be removed, but that requirement has since been removed. And this is to ensure alignment of regulations, as social distancing is not required outdoors in any other scenario. I trust that's helpful to members, and we're all happy to take any questions that you may have.
Okay, thank you. So is that all the briefings complete?
Yes, Chair.
Elaine? Okay, so Elaine, there has been some issues with the regulations that are before us today. Cross number, can you outline the issues that there have been in relation to 349 and 350?
Yes. So 349, as you mentioned, was laid with an error in it that said laid in Parliament as opposed to laid in the Assembly. And just through human error, fixing that error created other errors. So essentially, the regulation that is in place is 349. We issued a correction slip this morning, in fact, to the Business Office, and they will process that shortly. 350 is not a legal regulation and should be removed. And we are working with the Statutory Publications Office to get that removed as well.
Okay, and in relation to 348 then, how does the Executive's decision to suspend the plan affect the rule? And will that rule be revoked, or is that rule being amended, or where is that at now in relation to the executive decisions recently?
Jane, do you want to take that question?
Yeah.
So
Jane, yeah.
Sorry,
Chair. Question, Jane. Okay.
Just to clarify, this is refers to the extending of the grace period for exemption on face coverings. Yes. So
yes.
The Executive is actually considering a proposal on how to take this forward. So the grace period remains in place. So it's being considered as we speak. So at the moment, I can't give you an update on exactly where it is, but a proposal has been submitted to the Executive that is now being considered today.
And is that likely to lead to the revocation of this and the replacement with another one, or will it be an amendment to this, or how will that work in practice?
It would be an amendment. Oh, sorry, Jane, go ahead.
Sorry, I was just going to say that it would be an amendment. Yeah.
Okay. Okay, the final one, I think, for now from me, and I have a few indications from members as well. But in relation to 348, and I know my colleague Patrick Delargue has raised issues around disability and potentially discrimination, disability discrimination. So do you think that the onus on a disabled person to provide proof of exemption could be considered discriminatory if other people are not similarly required? Has that been considered?
We are currently considering that at the moment and conducting a full equality screening process at the moment in conjunction with our lawyers. So at the moment, that's really all I can say on that. But yes, we are considering it in depth.
Okay. Okay, I'm going to go across to members then. So first of all, I'm going to our Deputy Chair, Pam Cameron. Then I have Jerry, Carol, and then Colin McGrath have indications in that order at this point in time. So Pam, go ahead, please.
Thank you, Chair. Thank you, Elaine, and the panel for your attendance at committee today. I just wanted to ask you in and around what guidance has been provided to businesses and retailers on what constitutes reasonable measures in the context of promoting compliance with the face covering regulations.
I'm going to ask Jane if she's able to take that one.
Certainly, yes. We have had extensive engagement with retail and hospitality premises, and in terms of compliance, of promoting compliance with the wearing of face coverings, we've had the guidance that has been developed and will be published very soon kind of outlines measures such as having effective signage in place, doing tannoy announcements, encouraging staff who are not exempt to wear face coverings. And there may be some circumstances where the business may feel comfortable in asking somebody why they may not be wearing a face covering, but they do not have an enforcement role.
Okay, thanks for that, Jane. And I'm sure you'll be aware, I did raise this at a previous committee, the example of a lady who has been the victim of trauma and domestic abuse who cannot wear that face covering for those reasons, but who will also not have medical evidence as such, as in physical evidence even with her doctor to back up that claim. So I'm just wondering how that type of example, how that would be dealt with.
That is included in the proposal that the executive is considering at the moment, so that has been covered.
Okay, so we'll hear more about that at some stage.
Yeah, once we have an executive decision, yeah.
Okay, thank you. In terms of the lateral flow test results within 48 hours prior to entry being no longer acceptable in the context of COVID certification, how does this compare with the situation with international travel?
So the LFD result is still accepted. It's just the chiming that's changed slightly. I'm not sure how it links with international travel. The reason for our change was because if you upload an LFD test result to the system, you can only do it for today or yesterday, and there's no timestamp on the notification. So the sample, it's really just by the day of the sample rather than the date. So that would have made it difficult for a venue. Say, for example, an event was on a Saturday evening. If a person had a result from Thursday, it would be difficult to know if it was in the 48-hour window or not. So just to provide that clarity for enforcement officers and for venues, it's the calendar days is being used instead. So I wouldn't know how that links with travel, but we can certainly provide that information to committee afterwards.
I appreciate that, Clara, if you could get that, Elaine. And the final one for me, Chair, is I wanted to ask what data is being captured in respect of COVID certification. How is transmission linked to these settings being monitored?
In terms of the transmission element, I'll take that and then I'll maybe hand over to Jane on the data for the adherence generally. The transmission is being monitored really the same way as usual, in that there's a kind of a surveillance by the Public Health Agency on clusters and outbreaks. It won't be possible really to determine exactly what impact certification as a measure itself will have on transmission. We've always said that it's difficult to pinpoint the exact impact that one measure has. It's a package of measures really that just bring everything together and have the impact collectively. So that is still being monitored through the Public Health Agency, and they publish a weekly report on the clusters and outbreaks that's online if for anyone who wants to look into that in more detail. And I'll maybe ask Jane then on the data for certification generally if there's anything from her side.
Certainly, yes. In terms of data for certification, we can provide information in relation to how many certification applications have been made, if that would be helpful. And in terms of adherence, evidence back from the police and local government is that there is good compliance across businesses. Very rarely is there any need to go as far as enforcements. The police and local government are engaging their 4E model, which is to engage, educate and encourage before they would go as far as enforcement, and that has been effective to date. I think the only instance where there might be any enforcement required would be where there is a number of breaches of the COVID regulation by businesses, and in which case the businesses are asked they're given closure notices until it's fixed, and it's very rarely any longer than 24 hours, and then they can go back and be inspected, and there's evidence that the issues are being addressed effectively.
Okay, can I thank you both for that? I suppose, Jane, any information that can be provided to committee is good and welcome. Thank you for that. I suppose
Certainly.
Just maybe as a final comment or question, Elaine, given the changes in testing and given that even the Chief Scientific Advisor has said now that infection numbers are actually not effective in monitoring where we are in the pandemic. I'm just wondering how does that all marry up now that when you have much less figures or you've less accuracy now because you're relying on people reporting lateral flow test results online. I suspect that's probably not happening to a large degree. I don't know how you track that, and I don't know how you compare that. I don't know how you gather information on the clusters and outbreaks. I don't know how the PHA can contact trace given that particular change, and we understand why that is because of the huge volume now of positive cases. But how do you gather evidence, and how do you link that to the effectiveness of the COVID certification scheme?
Yeah, so thankfully, and I suppose in some sense surprisingly, it actually has been quite good in that people have been reporting the positive LFD test to contact tracing, and they're getting those literally by the thousands every day. So there has been a really good uptake on that from the general public, and we should thank them for that and encourage that to continue. And once they notify that public that positive result, it's treated in the same way as any other would have been. So yes. The scientific team are creating kind of almost like a new baseline comparison with the changes in testing to try to ascertain sort of where we're likely to be in the pandemic. I think in terms of the kind of the future and assessing the restrictions, the hospitalizations and the pressures on the health system will probably become the more important indicator, which then creates the challenge that we will have to move much quicker whenever changes are needed, because we don't have that sort of 2-week lag before the serious illness would kick in. But so far, things seem to be quite stable or coming down, certainly in the last couple of days. So we are quietly optimistic, dare I say it, that we might be okay at this point anyway. Things can change, of course.
Thank you, Chair.
Thank you, Pam. Going then to Jerry Carroll. Jerry, Lanneray, Liddahall.
Thanks, Chair. Thanks, panel. Couple of questions. The face covering regulations and the reasonable excuses criteria. I agree with some of the comments the Chair made. I think there's massive problems with this. It's laden with problems. Already people with disabilities have been in contact with myself. I'm sure other MLAs as well, people with autism and other. We basically find this regulation quite stressful and harmful even. And that I think has to be stated. I think it's the wrong approach to go down. I think obviously people should be encouraged to wear masks if there's no underlying medical reason for them not to do so. And I think encouragement is definitely better. And I think there's a question around mixed messages coming out about masks, which has caused confusion and undermined the process. I'm not saying anybody presenting today has done that, but really just maybe a question for the committee more than anything on that is, I don't know if it makes sense for us if we're voting on this today, and there's going to be a new SR effectively coming through, which is if I understood it correctly, where the executive are going to remove the requirement for people to present a reasonable excuse for exemption. So to me, that would be a totally different and new SR. So procedurally, politically, I don't know if it makes sense, but happy to if somebody can come back on that at the end. Just two other questions. The exemption around transport services, if I heard Niall, I think it was correctly, just a clarification, is that just an exemption just on ferry services outside and no other transport service? And then finally on number 21, 350, I've raised this at the start when the requirement to be seated in the hospitality venues that was lifted several weeks ago. I raised the concern about that then. I cited a lack of evidence, a lack of medical reasons for doing so, but it was still obviously decided to go ahead. Now the opposite decision, this has been revoked and a new SR put in place. I think it's right that the hospitality people should be seated in hospitality venues, but again that creates confusion. It's implementing a rule change and then changing it several weeks later. So just on that, and my final question, has there been any new evidence that's come to light from any of the officials here, the departments, any of the officials to clarify, to support and to back and maintain being seated in hospitality venues to reduce cases? Thanks.
Okay. So firstly, I think I should maybe clarify that I don't think Jane or I intended to convey that the executive were going to remove the need for a person to prove their medical exemption. The whole process that might be put in place is what's being considered today. So I wouldn't want to preempt any executive discussions and make sort of suggest that that's the way it's going to go. It might not be. Niall, do you want to take the ferry question, and then I'll come back and do the number 21?
Yeah, thanks, Elaine. So, Jerry, on the ferry, it was the case that this it was an oversight on our part that this wasn't changed some time ago to align with other social distancing requirements outdoors. So it was really a tidying up of that regulation, and it did just does apply to the outdoors area on a ferry. So it's pretty specific in that case.
Thanks, Niall. On terms of number 21, I'll ask David if there's anything specific on the amendment itself to add, but just the general point about the situation being confusing with quick changes. I think it's really down to the fact that legally speaking, and from a just sort of a policy and ethical perspective, the regulations, no restrictions should be in place longer than it's needed. When things are withdrawn, it's because the public health evidence and once considered by the executive, and they conclude that it isn't needed, and so it wouldn't be appropriate to keep something in place. And I do accept that the constant changes where things are undone and then redone creates a challenge for people trying to remember what the requirements are at any particular time. But at the same time, we couldn't keep measures in whenever they're not warranted. So I guess the advice would probably be just to keep regular checks on NI Direct and the My Business Info pages online, and certainly we always publish whenever new amendments are made, and the written ministerial statements from the executive always give the intention before the regulation comes out. So I'll just ask if David has anything specific from memory from when number 21 was made that he might want to add.
The only thing I would add, the intention was very clearly to reintroduce restrictions that had been in place rather than trying to introduce something that was slightly different or a slight variation. So it was a reintroduction, which I think was an important part of it.
Yeah, thanks. And just to clarify, there was no, as far as I'm aware, evidence provided for the initial removal of being seated at hospitality venues, and that's the point that I'm making. It creates confusion if it's now being reintroduced, if there's no medical reason stated for the initial revocation of it and then introduction. So I think it's important in terms of creating a clear picture in the public, and if they or if we're to encourage and make sure that they abide by the regulations. That's me. Thanks.
Thank you. Colin?
Thank you, Chair, and thank you for the updates on the regulations. Just, it's a really quick question, I suppose, in essence, because they're fairly straightforward. One was just to ask about the issue, is that a prescriptive list in terms of being able to move about in a hospitality sector? Because I know that I've had questions from people regarding gaming machines and pool tables, which is often for many people their motivation for actually going to a hospitality establishment, and there has been, because it's not specifically listed anywhere, are we to infer the fact that it's not listed as one of the acceptable reasons for moving about an establishment, therefore people shouldn't be using those? And the other one was just about the issue about the change to bring around that it's a point of entry is where you actually take people's to check the certificates and compliance, because I know for many organisations and many establishments that has become quite problematic and has resulted in having to employ extra staff, and that's where a lot of the costs from. And I'm just wondering, it's a one-size-fits-all policy, but there's obviously not one size of sector out there. I mean, you would have many rural pubs where there's just one person working in behind the counter, and that person is there for the whole evening, and there may only be a handful of people that come in, and that there's this creation of having to serve somebody, point to people, tell them to stay behind a door until they walk their way around. So, I mean, is there any way or opportunity for that one to be fleshed out to sort of say that, once your establishment is 50% or more capacity, then you need to move to point of entry, or if it's less than that, that you walk in and walk straight to a bar or straight to a table and get it scanned there? But just maybe some of the thoughts that there was in the background of that one.
Yes, so I'll take that second point and then I'll hand over to David for the games and snooker tables and hospitality. The point of entry checks, there was discussions at length on this with stakeholders as well and with enforcement. The reason to make the change was to ensure that there was a firm point at which enforcement officers could say, if this wasn't happening, you're not complying. Now, that said, there is always, they did recognise, enforcement bodies did recognise there needs to be a pragmatic approach, and there is a slight difference, a bit nuanced, I accept, that between what the legal requirement is and what you would enforce against versus a pragmatic approach, as you said, and particularly in rural bars where a one man behind the bar can see the full room, can understand who's there, and there's a small crowd. So the reason for the change is really just if there is a non-compliant venue, if there's no checks happening, if enforcement needs to be taken, that the law is clear on the requirement and that the police or the enforcement officers can take a case. It's not that they're not going to be pragmatic when they go out and visit places, and if the checks happen to be 5 foot through the door, that's a problem. It's not. What's important is that the law is clear, and that's why the amendment was made. So hopefully that reassures some venues.
Okay, thank you.
And David, do you want to take this games?
Yes, just in that list of exceptions to the requirement to be seated is a precise list of exceptions. They're not illustrative, but they are specific. Yeah.
Okay, so can I just confirm from that then, pool tables and game machines are out? I froze him with that question. Stunned him with that question.
Yeah, they are not listed as exceptions.
Okay, thank you. Paula, go ahead, please.
Thank you, Chair. Apologies, I was taking a phone call there, so I'm not sure whether I missed this question, but it was about getting the booster onto the app. Is there any progress on that? Thank you.
I don't have a timescale at hand, but I do know that there are plans to try to get it done this month, so that it would be available on the app, because I understand it's actually already needed for some countries for international travel, and there is a process where you can get a single dose QR code from the certification system, so if a person does need that, they can phone up and still get it now, but I understand the intention is to get that on the app this month.
Yeah, no, I was aware of that. It's a bit more complicated, but no, thank you. That's fine, thank you.
Thank you. And Alan?
Just recently received, in fact, just yesterday, I received an email from a constituent who works in a coffee shop environment. She's worked for this company for 3 years. She suffers from anxiety, and she had declared that at the commencement of her employment, and it is on her employment record. The company wrote out to all their employees and said that they were changing the policy that they all staff, while working in the coffee shop, had to wear a mask. She indicated to them that given her anxiety, she couldn't deal with that, wouldn't be able to cope with that. So they asked her to get a letter of exemption from her doctor, which she was unable. The doctor more or less refused to issue such a letter, and increased her medication to take account of her increased anxiety at the moment. Long story short, the company has now told her that unless she gets this letter, she will be disciplined. So she's went out on statutory sick pay for 2 weeks to try and buy a little bit of time. So I'm just wondering, is the company, if the panel could tell me, is the company being unreasonable, or are the company absolutely complying with the letter of the law as it sits at the moment by insisting that this waitress either wears a mask or produces a medical letter of exemption?
I think there's at least some of that case would probably stretch into employment law and depend on the employment contract, I would suspect. Certainly in terms of face coverings, there's no process by which a medical professional in Northern Ireland issues an exemption for face covering wearing at the moment. We've advised on our websites and on NI Direct that the public should not contact their GP asking for exemptions for wearing face coverings. GP services can't provide that service with such demands that's already been placed on them by people who are much more ill than people who need necessarily just to get a paper exemption for face coverings. So that is our public advice, that people do not contact doctors for that. I think that certainly would need to be a conversation with the company on that basis, but that would be our advice at the moment. There isn't a medical process to get an exemption in Northern Ireland.
Okay, so I can confirm that to this lady that's the policy that doctors will not issue. So therefore, it would appear to be unreasonable for the company to insist on something that the employee would find it impossible to produce. Thank you.
Thanks.
Okay, thank you. I have a printer started to do some sort of an alignment or something here, so apologies if that noise is feeding through. I don't see any other indications. I've just checked with the clerk. Are there any other indications from members, clerk?
Sorry, Carol was looking in, Chair.
Sorry, yes, Carol. Yes, indeed. Go ahead, Carol, please.
No, Chair, maybe you're going to cover this in your alignment. My understanding was, I mean, some of these are subject to the examiner statutory rules seeking further information, so we're not going to cover them all today.
Yeah, I'm going to come to them individually, and there are some proposals that I want to make in relation to those. Okay, so listen, Elaine and your team there, I think that's everything there for members for today. Pam, are you looking back in on an issue? Pam, I see your hand raised again there. You looking back in? Yeah.
Yes, thank you, Chair. And it's maybe a little bit unfair, but just given the breaking news around the self-isolation period, which is going to be reduced to 5 days in England, maybe you could give us a heads up whether we will follow suit and whether that timing would be the same.
There's none of us that would be involved in the self-isolation proposal, so I honestly don't know. Sorry.
That's worth a try. Thanks,
Okay. Well, I suppose we can pick up on that by way of writing to the department, maybe, Pam, because it is an issue of concern, I have to say, and I think quite contested within the scientific fraternity and medical. So, okay. Well, listen, I think that's everything then, Elaine, for your team for today. Thank you for coming along. I want to wish you all a very happy New Year, and take care until the next time. I'm sure you will be back with us again, and we'll go through now individually the different ASRs that you have briefed us on. So thank you for that, and we can continue.
Okay. Thank you.
Okay. Okay, members. So I'll just go through them individually because there are a number of problems here that a number of issues arising that we need to take account of. So we'll go through them just step by step. So the first one then that we're going back to for formal consideration is SR 2021/334. I can advise members that the Examiner of Statutory Rules has no issues to raise in relation to this SR. Do members have any further issues they wish to raise in relation to that one? No. Thank you then. And that one was fairly straightforward out of all, and that was the one that didn't really have any particular problems. But so therefore, can I ask the committee ask members to agree formally that the Committee for Health has considered SR 2021/334, the Health Protection Coronavirus Restrictions Regulations NA 2021, Amendment Number 20, Regulations NA 2021, and recommends that it be approved by the Assembly. Are we agreed? Agreed, yes, thank you. So members, then the rather more difficult one on SR 2021/348, and that's the face covering ones. We are aware that the Examiner for Statutory Rules has written to the Department on this rule, so therefore I would suggest that we defer our decision until further clarification is provided. Do members have any other views, or are members content with that?
Great, Chair.
Members content, thank you. Okay. Moving on to SR 2021/350, and that's the one that was replaced with 349. So can I remind members that due to a number of errors in the laying of this SR, the SR has now been replaced by SR 2021/349. The Examiner of Statutory Rules has reported that she's satisfied with the Department's approach to addressing these errors. The Examiner has also commented on a minor drafting error in SR 349, but is content that the Department will issue a correction slip and has no further issues to raise. The correction slip, however, has not been provided, and therefore I would propose that we also defer agreement on this SR until the correction slip is received. Would members be content with that? Yeah, thank you. Moving on then to draft SR, the coronavirus. So that's the ones that we have considered from Elaine's team there. Item 11 then is, I'll just double check, Chair Clerk, we have covered all of those SRs there.
Yes, Chair, they're all grand.
Okay, thank you. So members then, draft item 11 is a draft SR. This is one that we would have seen at SL1 stage, and we have put questions in relation to that at SL1 stage. It's the Coronavirus Act 2020 extension of powers to act for the protection of public health, Order NA 2021. So that's the extension of the underpinning powers that we've already discussed. Members will recall that we were briefed by the Department on that policy proposal at our meeting on the 25th of November. The Department has advised that due to drafting errors, this SR has had to be relayed, and a new draft was received by the committee yesterday, and only yesterday. The committee wrote to the Department following the meeting on the 25th of November seeking further information on a number of issues in relation to the SR. However, the response to those queries has not yet been received. So are members in that circumstance content that we defer consideration of this SR until next week, pending the Department's response? Yeah, content. Thank you, members.
Chair, could I just ask a technical question on that? Because I know that with limited understanding with SRs and laying them, there's only so many times that there can actually be sittings of the Assembly or a period of time before they fall away. If this one was presented to us in November and it still hasn't gone to the Assembly, is there a timescale issue that kicks in there, or is it that they've just completely dropped the old one and they're introducing a new one?
Well, my understanding, but I will check with the clerk for clarity, but my understanding is the SL1, that will be a more normal process where it comes by SL1 and there's a more extended time and the more appropriate. That hasn't been possible with a lot of the interim ones. However, it did come as an SL1, and that's part of the time factor, but I'll just check with the clerk in relation to the other issues you have raised there, Colin.
Yes, Chair, you're correct in saying that when we first considered it in November, it came in as a proposed SR under the SL1 process. So the SR has now been relayed following some errors. This is due up for debate at the minute. It's scheduled for, I think it's Tuesday the 25th. So we do have, in theory, another week to consider it. But the issue being that we had a couple of questions back in November that haven't been answered yet. So we're keen to get that response before the committee can formally approve or make a decision on it.
Yep. Does that clarify okay, Colin? And members have indicated, I think, broadly that they're content that we defer, based on those issues, that we defer consideration until next week. So, members, we are now going into our deliberations in closed session on the Adoption and Children Bill. So I'll ask the clerk just to take us out of public session and to indicate when we are in closed session, please.